Boom. Hey, folks, how's everyone doing? Hopefully, people are having a good day. It is a Monday. Mondays are not the best day, but we will see what we can do here. I see somebody was asking about Ethan Klein. We could talk about Ethan Klein a bit. The Ethan Klein thing is a bit interesting, but we have a lot of Randazza on the plan. Now, you may not know who Marc Randazza is. Mark, and I might be mispronouncing his name, but he is a First Amendment lawyer. He talks about, or he helps people when there is somebody who is trying to silence them in various ways. Now, the thing is I would totally hire him for some of the stuff I've got going on, except that he probably is out of my price range. He's very good at what he does, and he is very expensive. So that is yeah. Oh, hello. Hey, all, looking forward to this. So yeah. I see close enough. Yeah. And I mean, he's expensive because he's worth it, but so that is really what we're going to be talking about today, is a couple of the lawsuits that he is in my view on the right side of, which now, I mean, all of that can change, but so far it is, with new evidence. But so far, these are lawsuits that look kind of crappy for the plaintiffs. So one of them involves dueling magicians. Now, if you don't know the magician sphere of things, magic is contentious. Most or a lot of magic tricks are done with little sort of clever mechanisms or the like. And they get really particular about, like, revealing secrets. They get particular about, who's got which tricks, and they get into fights. Dueling magicians. Yes, that is exactly what I said. And you might be saying, how could you get magicians dueling? Well, let's pull that up here. We're going to... I need to pull up the right screen. There we go. Boom. There we go. So this is the case of Masika Magic versus Penguin Magic. But it also is Yigal Masika, I'm probably mispronouncing that in the worst way, versus Craig Petty and Doe's 1 to 10. And this suit is for libel, trade libel, common law, misappropriation of likeness, commercial misappropriation of likeness, false light, California Unfair Trade Practices Act, so CUPTA, false or misleading statements when advertising one's good, unfair competition, false designation of origin, and intentional interference with prospective economic advantage, and declaratory relief against defendants. So this is basically, all of this boils down to, when you see all of this, you know that what we're talking about is a hurt feelings lawsuit. You might recognize a bunch of these claims from a certain case I can't cover at the moment, but that is, you'll also recognize a lot of this from cases like, if you followed the Proven Industries stuff, where they sued they sued over, why are you making us look stupid by showing how weak our locks are, this kind of stuff. So let's get into it. Let's have some commentary on this one. And yeah, it is a short thing at 46 pages, so we're going to skim parts of it. But what is going on here? Masika Magic, we're going to skip over all of these details about where they live. But let's see. They talk about all of this. On information and belief, defendant Craig Petty is a resident of the United Kingdom. Defendant Craig Petty is an individual associated with Penguin Magic's promotional media and content. On further information and belief, Craig Petty conducts business within the United States, including the state of California, offers video presentations relating to his activities and offerings in the magic industry towards persons within the United States, including the state of California, and directs his commercial activities at persons and entities sitting in the United States, including the state of California. Upon yet further information and belief, defendant Craig Petty announces commercial activities in the magic industry in cooperation with defendant Penguin Magic, including participating in magic trade shows within the United States. Okay, so this is the reason why they're putting this is because Craig Petty is in the UK, but for some reason they've decided to sue him in the United States. And I don't really get that one because if you're suing over, well, yeah, it makes no sense that they're going after him in California as opposed to the UK. But yeah. All right. I am setting a goal. It's not really a goal because the goal is enjoy a martini, and I already have the martini. So yeah. So plaintiffs are informed and believe that Craig Petty is responsible for some of these things. Jurisdiction and venue, we can skip. So basically, let's get to general allegations. Yigal Masika is the owner of intellectual property related to, including inventions, patent applications, patents, trademarks, trade secrets, know-how, and confidential information relating to magic tricks, demonstrations, instructions, and other means of entertainment. Plaintiffs market, distribute, and sell products using such intellectual property rights. Plaintiffs have developed a fine reputation and goodwill at substantial expense associated with their intellectual property. Now, this is interesting because, oh, yes, dismiss the message. This is interesting because when you look up Yigal Masika, his reputation is not exactly fine. His reputation is controversial, I guess would be the way to put it. There are a lot of people who don't like him. That doesn't mean he doesn't, enjoy a certain reputation, but also there are people who don't like the guy. So that is worth noting. But he sells magic tricks, amongst other things. So he notes that he participates in various industry associations, including the Academy of Magical Arts, FISM, Magic Live, Magic Cafe, etc. Upon information, defendants advertise, market, offer for sale, and sell products that compete with the plaintiffs in the United States and the state of California and in this judicial district. So plaintiffs' Loops products are competitive with defendants' Tais products, an inferior product not authorized by plaintiff offered by Penguin Magic. So these guys both sell magician stuff. And a lot of the, if you see magic tricks, especially street magicians and so forth, a lot of the stuff they're using is stuff they bought online because it can be very difficult to invent new tricks. And so there's various companies that sell different methods of doing these things and working these things out. So just be aware that is a whole thing. Now there's the sort of highest echelon of I don't know what they call themselves, magicians, I guess, but at the highest echelon, you've got the people who invent their own tricks. So if you go to see, for instance, Penn and Teller invent a lot of their own stuff. They put a lot of effort into it. And a lot of their stuff, they're very careful to keep the secret so nobody knows how it works except them. So, defendant Craig Petty has held himself out to the public as representing Penguin Magic at various places because they're suing Penguin Magic. So, and then they've got transcripts. They say specifically, he stated from 1945 to 2017, I've spoken to the people at Magic Live, which is coming up soon, by the way. I hope everyone's excited. I'm going to Magic Live. I'm going to be there. I'm going to be arriving, I think, on the 2nd of August. So if you're coming to Magic Live, make sure you come over and say hi. I'll be in the bar having a drink. I'll be on the Penguin booth. So actually, I'm going to be there on behalf of Penguin Magic at the Penguin booth, etc. So, all right. He regularly constructs demos. We're going to skip to where they actually have issues. We're going to skip over he is affiliated with Penguin because, yeah, okay. So now they've got this second amended complaint, and so I skipped over the first amended complaint, but yes. All right, so he gets sued. They say Petty doubles down on the exact defamatory statements from his Desolation of Yigal Masiko video, where he already knows from the surface of the First Amendment complaint were the subject of the litigation. In the Sued for Speaking Out video, available at, he told his audience, in that video, I referred to him as Magic's biggest litigious bully for the last 3 years, and I stand by that opinion. He's a patent troll. He uses the courts to bully people into submission. So what is a patent troll? What is what sort of is the allegation? Well, patent trolling is kind of a pejorative term because what a patent gives you a right to prevent other people from doing things. It's kind of an unusual right in that aspect because most rights that you have are like nobody else can stop you from doing a thing, right? Like your right to freedom of speech means that like the government can't come in and, silence you. Your right to, if you're living in the US and you have a right to, a Second Amendment right, it means you can buy guns and nobody can stop you. But this is a right to actually prevent other people from doing things, which is kind of how property rights typically work, is that you get to exclude other people from doing things. So the idea behind patents is that in exchange for making an invention known, making it available to the public how things work, that you get a right to exclusively use that for a particular time. So let us imagine that I invent, a new thing and decide to patent it. Like, let's say I find a invention that is an improvement on this bottle in some way, right? I find a new way of bottling stuff that nobody's ever thought of before. Well, the trade-off to a patent, what I give up, aside from the whole patent application process, which is nightmarish and expensive, but aside from that, I have to tell the world how my invention works. Like I have to set it out there. And then in exchange for that, the government says, okay, no one else can use this invention. Like nobody else can market it. Nobody else can sell it. Nobody else can any of these things except you or people you license for a given period, which might be like 30 years. But at the end of that time, that patent expires and then anybody can do it, right? So if I patent, at some point somebody might have had a patent for like this particular closure on a folding knife, right? I'm just trying to think of something that's recent enough that so like this little locking system here that keeps the folding knife from collapsing on your hands, unless you're in the UK, in which case it's supposed to collapse on your hands. But that folding, lock system, somebody patented that probably at some point. And now that the patent has expired, the patent for that has long since expired, so you can find this same locking mechanism system on lots of different knives, right? Because now that the patent is expired, that information is publicly known, and anybody can use it. So there's that. So, but patent trolling is a different thing. Patent trolling kind of implies that you get, it implies that you go and get sort of shaky or shitty or debatable patents, and then use them to extract rent, essentially, from people, like in the economic sense, economic rents. Because if you get this crappy patent, the patent might be, the patent might not be something that holds up, but you can like threaten to sue people and get them to pay you instead of having to go through costly litigation. So patent trolling, as a pejorative, when you say somebody's a patent troll, usually what you mean is that they're getting kind of shaky, shitty, not so good patents that might not hold up, but that you are then using them to basically force people to pay you, force people into silence, this kind of thing, right? That's sort of the allegation there. So, in his sued for speaking out video, Petty demonstrated actual malice while inciting others to attack Masika, including when Petty explicitly instructed his viewers to amplify the attack on Masika at about 7:56 through about 8:22. Let's all talk about it as a community. Let's have a discussion. Share this video. Yes, but talk about it. If you're on Facebook, make a Facebook post. If you're in a community somewhere, make a post. If you have a blog, write a blog about this. If you're a vlogger, make a vlog about this. Make a podcast about this. Discuss this with your friends. Discuss this with fellow magicians. So I guess magician is the right term. The thing is that this all sounds like, let's do a freedom of speech. Let's do a First Amendment, guys. So, okay. Now, interestingly, yeah, it's weird because their Second Amendment complaint seems to assume you've read the First Amendment complaint, which isn't actually good drafting because you're not supposed to do that. All right. Defendants are engaged in an ongoing malicious campaign to destroy plaintiff's reputation, actively instructing their followers to spread the defamation across the internet and elsewhere. Craig Petty, now this is their Second Amendment complaint. You'd think that they would have mentioned what the alleged defamation is. So, all right. They discuss Penguin. Okay. All right. Craig Petty set up a public fundraising campaign via GiveSendGo to fund his fight against the plaintiffs. Attached here too is Exhibit H to the Second Amended complaint is a true and correct copy of Craig Petty's GiveSendGo campaign site, available at, and they give the entire URL. Now, why would Craig Petty set up a GiveSendGo? Well, remember how I said Marc Randazza is very good at what he does and also very expensive? Well, that's why he's got the GiveSendGo, because he's got legal bills. Let me just see if I can. So this is the that is the GiveSendGo. The plaintiffs wanted us to have it, so I'm going to share it. He says, and so here we are. The legal fees are not going to be light, and bullies know how to run up a tab so that a case that should be over quickly can continue for a long time. To fight this case, I need your help. You see, I'm launching a crowdfunding campaign to help cover the costs of legal defense. So defendants' conduct has successfully incited a targeted boycott, resulting in current and ongoing lost sales. That'll be part of their damage claims here. Petty's GiveSendGo campaign donor list reveals that the very people Petty interviewed to defame Masika in the original Desolation of Yigal Masika video are funding this attack. Mark Bennett, for example, who Petty championed in his video, donated $500. Or somebody claiming to be him, João Miranda, who also appeared in the video claiming that Masika intimidated him, donated $1,000. Okay, so people like, they're like, why is our campaign like, this is already the illustration of the Streisand effect, because all of this stuff happens after the lawsuit. And so the problem is that once you file a lawsuit, people react to the lawsuit, right? People go, hey, I have seen your lawsuit and you suck as a person. Over and over and over again, people do not seem to clue into this, and they file defamation suits, and then they are shocked that the defamation lawsuit makes things worse. The Streisand effect is, of course, named for Barbara Streisand, who sued to get a picture of her house taken off of out of an article, and as a result, so many more people were interested in that picture of the house than they would have been otherwise. But like, let's consider this as an example. Let's say somebody on Twitter goes and, says something like, Runkle, you are a shitty lawyer. Okay, well, I'm not a shitty lawyer, but they say that I am on Twitter because they're people on Twitter, right? And so I go and or like, let's say they get real specific about it. They say like, Runkle, you lost, one of the cases I've lost, because every lawyer loses cases. You lost this case because you're a shitty lawyer. If I decide to sue that person, then what I'm going to do is get a whole lot more interest in the question of whether or not I'm a shitty lawyer. And the thing is that I cannot guarantee by any stretch that that the people will be on my side. In fact, as a general concept, when people decide to sue over this, it tends to convince people that that the subject matter has merit. I hope that's not vodka. This martini glass is full of a proper dirty martini, which means it's got lots of olives and a bit of splash of olive juice, but it is gin and it is vermouth. The gin is this is Tanqueray, so it's a decent juniper-y kind of gin. So we do not do vodka things here. And yeah, Marc Randazza is probably the preeminent 1A lawyer. Not only is he like, the other thing about Randazza, and I having to sort of catch myself because I keep remembering he's in the chat, and now it's going to sound like I'm sucking up. But one of the other things about Randazza has a certain flourish to him. He has a certain bombastic quality where he does not mince words. He comes in and he is flamboyant in terms of like, we'll see. You'll see it when we get to it, right? So, yeah. Been a while since you've been on Rumble. You're not wrong, but that's mostly because Rumble makes things a giant pain in the ass to stream there. All right. So the comments on the video demonstrate that defendants are inflicting direct continued commercial damage with all of these videos. Commenters have stated, I threw out my Yigal Masika stuff. I will personally not buy any of his products anymore. Imagine if the entire community stopped buying his stuff. The entire community needs to boycott Masika. I'll never buy his products. No more M items for me, and other calls for boycott and commercial harm. The thing is that a lot of this stuff isn't going to be about any alleged defamatory statements. this is going to be about the fact that you chose to sue somebody. Like, you chose to sue somebody. People online hate the use of the court system to silence your enemies. They really do. And so the internet norms for this basically say that if somebody is saying shit about you that you don't like, either ignore it or say your own shit. Talk back to them, right? Like, but don't go and use the courts like a bully and, back people off. That is kind of the internet norms. So Petty frames plaintiffs' legitimate use of the courts to protect plaintiffs' intellectual property as malicious and abusive. This, of course, is entirely like freedom of speech issues. He uses the courts to bully people into submission. And since nobody has stood up to him or being able to stand up to him or financially being able to stand up to him, he's further emboldened because that's what bullies do. They keep repeating the same behavior over and over again until they meet resistance. And now he's trying to use his bully status to shut down any criticism. He's trying to use it to shut down free speech. He claims Masika is somebody who's trying to legally silence me by playing a game of who's got more money to burn. All of this sounds to me like First Amendment expression, right? Somebody calling you a bully is going to fall very squarely within the matter of opinion. So I'm like, why is all of this in here? So far, there's a lot of talk in this lawsuit and not a lot of meat. I am just like, where's the meat? When you see a lawsuit that goes through this much spin up, it usually means they're trying to hide the ball a bit because, quite frankly, if, like, let's imagine that, like, A. Hettinger walks up to me in the street and punches me in the face and breaks my jaw and I lose 3 teeth. And, let's say they're my front 3 teeth. And as a result of that, nobody wants to watch my YouTube videos anymore because I look weird and I suffer all of this damage. Well, in the eventual lawsuit, I would start with, on such a day, in such and such a place, A. Hettinger decided to punch me in, like, for no reason, punched me in the mouth. You lead off with the good stuff, right? And so when they're leading off with all of this, like, we're at page 13, and I still don't know what the actual claim is yet, then, yeah. So Eric Tait is the primary product producer, marketer, and public face of Penguin Magic, with his fingers in every single trick. In that role as a Penguin Magic employee, Eric Tait's podcast statements regarding plaintiffs were made strictly within the course and scope of his employment to manipulate the magic market and suppress a competitor's products in favor of the Penguin Magic products Tait himself develops and promotes. So he was interviewed. The interview is available online. He stated in this interview, so, we take a look at your trick through the submission process. We decide that we want to have you in because Penguin wants to produce it. And then when it gets down to the brass tacks, we're going to actually make the video of the instructions. I'm the guy that you film it with, Tait says in the interview. So I got my hands in a lot of pots, but I guess I'm best described as a producer. I sort of help move forward products to market with Penguin Magic. Okay. Eric Tait is also involved in managing their website and online marketplace. And because Eric Tait's explicit job is to evaluate competitors' products, vet submissions, and bring Penguin Magic's own products to market, his statements discrediting plaintiff were made strictly within the course and scope of his employment to manipulate the market in Penguin Magic's favor. So this is their second amended complaint, but it really looks like they amended out all of the actual claims, which is weird. So before Penguin Magic began heavily pushing its knockoff Tait product, Eric Tait hosted Yigal Masika on the Penguin Magic podcast on June 24th, 2021, where Tait heavily praised Masika's inventions, state that all his products are highly refined. Tait further stated that he really likes Spider Pen and has used it a lot, while acknowledging that loops are standard now. This interview was in the Penguin Magic podcast with Eric Tait. So, giant fucking URL. Why is this URL so giant? Okay. Guys, it's okay to use a URL shortener. That's allowed. Later, defendants applied malice in making a commercial pivot by defaming Masika and attacking his products as stolen and garbage only after Penguin Magic began manufacturing and selling ties. Defendants' defamation was... What is the defamatory statement? We're on paragraph 40. Was not a matter of journalistic reporting, as neither Tait nor Petty have any journalism credentials. All right, so if I ever become a judge, if I am a judge, and if a case comes before me where somebody says defendant's defamation was not a matter of journalistic reporting, as neither Tait nor Petty have any journalism credentials, I am going to stop and say, can you tell me the relevance of that, counsel? Can you tell me why that's fucking relevant? Because the First Amendment was... I've gone on this rant before, but I'm going to go on it again. The First Amendment is not for the New York Times, because the New York Times came about after the First Amendment. The First Amendment was not invented for those kinds of people. The First Amendment was invented for people publishing, like, newsletters. Often those newsletters were published, like, in somebody's basement. The First Amendment was invented for town criers. When we say the soapbox, you know, I'm getting up on my soapbox to say something. Well, okay. The thing is that the soapbox originally referred to the practice of people literally getting up on a box or some other elevated thing so that they could shout over a crowd and they would pontificate. They were basically the first YouTubers before YouTube was a thing, because they would get up on like a literal box in front of a crowd and they would be like, I have opinions, or here is the news, or whatever. And they'd have a little cup or a container out that you could throw money into if you appreciated what they had to say. So literally it is for some jackass has an opinion and the government does not get to silence it. Journalism credentials is the opposite of the idea of the First Amendment. The First Amendment fundamentally is there to protect the ordinary person. And the second that we say that you need a journalism credential to be engaged in journalism, it means that you have somebody, the government, a university, etc., who gets to decide who is a journalist and who is not. Whereas in practice, you are a journalist if you do journalism, right? If you are breaking a story, you are a journalist. If you are commenting on a story and offering some new perspective or whatever, you are a journalist. This argument is the sort of thing that if I was ever a judge, I would be just pushing back on this every time and just be like, so why are you putting this in your shit? Because have you not heard of the First Amendment? Is this new to you? So, nor was the content of the video's general public or genuine public interest debate. How do you mean it's not genuine public interest debate? Public interest is determined by the public, not by you. And so you know how you know if something's a public interest debate? If the public is interested. We got 1,000 people watching this right now. That's the public being interested, right? So yeah. Instead, defendants conspired to enact a coordinated bad faith commercial attack designed to destroy the reputation of the market leader, Masica, so that Tait and Petty could step into the void and sell Penguin's house brand knockoffs at the conventions they jointly operate. House brand knockoffs could be, but this is in a filing, so they can get away with it. So, Penguin Magic podcast with Eric Tait, hosted by Eric Tait of Penguin Magic, was not merely hosted by Penguin Magic, but videos were published on the official Penguin Magic YouTube channel. Okay. I get it. They're saying it's officially affiliated with Penguin Magic. Cool. All right. So now they have a thing. Eric Tait shares his own personal story of Masica allegedly stiffing him on payment for writing ad copy and instructions 15 to 20 years ago, stating Masica paid for only 4 out of 16 to 18 pieces and then told him to lawyer up when confronted, even though Tait was a 25-year-old college graduate at the time. Okay, so I guess that's an alleged defamatory statement. All right, so they're going to litigate on the truth of that. Cool. Further, in Exhibit C, Eric Tait makes another defamatory statement. He summarizes that Masica's actions are used in an abusive way. Wait. Used in an abusive way is pretty textbook opinion statements. I don't see how they're... If this is as good as their claim is going to get, then holy shit. This is bad. All right, so Exhibit M is a true and correct copy of the Penguin Magic YouTube offering of its hosted video. The description of this video publishes a defamatory statement against plaintiffs. Whoever wrote this, the lawyer who wrote this, I have some opinions on, and those opinions are, let's just say he would probably sue me over them, even though they're opinion. Eric Tait, for the first time, shares a story of when he wrote ad copy for Yigal and how it didn't end the way he had hoped. The Penguin Magic video and the channel overall is branded with Penguin Magic's branded marks, is monetized through YouTube, and embedded with links linked directly to Penguin Magic's product pages, including products competing with plaintiffs and used to drive traffic through to Penguin Magic's platform and sales funnels. So, also publishes the defamatory video. What are the defamatory statements? Get to... Oh my God. We are at 18 pages and I still don't know what the defamation is. So, republished defendant Petty's Desolation of Yigal Masica video. Where is the defamatory statements? What is the alleged defamation here? All right. So Eric Tait's statements about unpaid work for Yigal Masica were made within the course and scope of his employment. Is that all they've got? Is that literally all they've got? Okay. Calls for a boycott. That is all, again, First Amendment. So they called him a bully, and I'm just trying to find here what the actual... Okay. One source of hate and ridicule demonstrated in the Craig Petty video and the Penguin Magic Tait podcast is plaintiff's pending patent application for an illusion device having a key with a retractable keychain clip. So, and then they list the patent. And in the U.S. patent application, the ring flight revolution is disclosed and described in paragraph whatever. Rinky Dinky product. They have a patent that is described as being able to incorporate an AirTag device. So, defendants published statements presented in video and audio recordings made several defamatory statements. Can you share with the class yet? You got to have some specifics. This is your claim. Made several defamatory statements. What are they? Regarding plaintiffs, including false statements regarding plaintiffs' patent portfolio. What statements? Plaintiffs' efforts to protect and enforce intellectual property. What statements? And plaintiffs' resort to litigation to protect the intellectual property and reputation. Wait, you are resorting to litigation. How are you proving them wrong by resorting to litigation? Defendants know their statements are false. How can they know they're false? I don't even know what their statements are. But for the sake of clickbait, ratings, search engine visibility, and views, or put plainly, money, defendants have destroyed plaintiffs' reputation and legacy through their false statements and implication that plaintiffs are patent terrorists with patents they do not deserve, bullies, and other inflammatory epithets. What are the statements? Oh my God, why do I have to keep saying this? So, video documentary called The Desolation of Yigal Masika, and various other things, both repeated and republished negative statements from third parties, including Sean Boguna, Joe Miranda, Steve Sheraton, Tom Wright, Eric Tait, Craig Petty, and Mark Bennett. The allegation that a bunch of people think you suck does not establish that it's defamatory. Because, for example, there are a whole bunch of potential defenses. You know, for example, truth is a defense. So if I say, like, Ted Bundy is a bad dude, I think he killed some folks. Like, Ted Bundy committed some murders. Well, he can't sue me if he's still alive. I expect he's not. But, you know, there would be a truth issue, right? So there's that. But also, the big one is opinion. You are allowed to state opinions. The thing is that defamation has to be founded on facts. And so those facts have to be, you know, it has to be that you're alleging something is true. So, for example, let's say that I say that Masika is creepy or weird or a bigot or, you know, whatever, right? All of those would be opinions. All of those would be things that are just like, because what does it mean to be creepy? Is there an objective standard of creepiness? No, there isn't. What is creepy to one person might not be creepy to another person. And so that is just opinion. There's no hard and fast. But if, you know, you were to allege that somebody, you know, you don't say just that they're a racist, but you say that person fired an employee for no reason other than their skin color. And so you set out that this person did a specific factual thing, then that could be defamatory because at that point you have now made a statement of fact. So these statements included defamatory statements presented as factual conclusions based on reported events and conversations, or are direct accusations of misconduct, constituting false defamatory statements. What are those statements? Please, for the love of God, tell me what the statements are. This is your lawsuit, guys. Like, you've got to actually say what the statements are. Some of these statements include qualifiers such as, in my opinion, or I believe, but these are still defamatory statements, as they at least imply defamatory facts or are demonstrably false. What are they? So, Eric Tait falsely claimed that he worked at one time for Masika and that Masika did not pay him as agreed. Okay, we're finally getting to a statement here. The conversation between Eric Tait and Craig Petty was recorded as. This is also, we were talking about an event that occurred 15 to 20 years ago. I mean, I was maybe 24 when this happened, and I turned 40 last week. So my friend Yigal needed a copywriter, and y'all, he worked for y'all. And so he reached out to me and said, Eric's a writer. He does stuff because I was a writer. I graduated with a degree in comedy writing and performance. And I was going to be a writer on the Joe Flitty radio program at the time until XM Radio and Sirius got together. And I'd done a bunch of writing for other companies. I was a story editor for a production company at the time. So I was writing on a regular basis, not just doing magic. So I wrote all this ad copy and instructions, and the deal was $100 per piece. And at the time, I also started getting asked to write weird pieces. So I remember writing some legalistic, aggressive letters about people. And I didn't really know much about, I wasn't super in the magic industry at the time because I didn't get into magic until I was 19. And then I was kind of away from it when I was just doing comedy in school. So I didn't know a lot on the industry side. So I just had this guy going, look, someone's infringing on this thing. We need to scare him with a letter. Can you write this? And I was like, sure, I can write something scary. Not a problem. And I ended up writing 16 or 17 or 18 pieces for him. The other thing you have to be concerned about whenever you file a lawsuit about defamation, one of the things you have to consider is that you are rolling some big dice. And what I mean by that is that you are deciding to pull out. Wait, I think I've got big dice. Give me a second. I've got a prop for this. Yeah, but I can't reach it. It's too far away. Yeah. Headphones. So you're pulling out some big dice. There we go. And the thing is even if you think that you have a solid gold case, even if you think that everything is perfect, there's always the chance that you roll that natural one in front of a jury and that they come back against you. So whenever you are running a defamation case, you always have to think about the possibility that what do you do if a jury comes back and says, hey, this is true? Right? What do you do if that happens? Because at this point, it looks like they hired this guy to do some legal writing, to play lawyer when he isn't a lawyer. This is a weird little thing there. So, and he paid me for 4 of them. And then I had written a bunch of stuff in a short period of time for him because he kept asking for stuff, and I would do revisions too. And as a freelance writer, it's very common for the deal to be you're writing per piece and you guarantee 3 revisions before you start incurring another cost for it if they're asking you to go back and change it again. And we had discussed this, and I think we even discussed it by email. I would have to dig back through 15 years of email on my AOL account as how far back this is. Yeah. And then suddenly the checks stopped coming. And so I reached out and I was like, hey, I've just written my 16th piece. The bill is, pretty high. And he said, oh no, the deal was for you to get $100 to write for me. And I was like, no, per piece. And he was like, no, it was $100. I gave you that extra as a nicety. And I was like, no, it was $100 per piece. Who in their right mind would accept a deal to write in perpetuity for somebody for $100? I was like, this doesn't make any sense. And his response was basically, well, if you really think that way, lawyer up. And I was, and I can't emphasize this enough, a 25-year-old college graduate living in Southern California. Lawyering up is not an option. Yeah, so I just left it alone, and I actually began avoiding Yigal at the castle because I was embarrassed that I let myself be taken advantage of in that situation because I really worked hard on a lot of that stuff. And again, it's being used, still being used to this day. Every time I see certain advertisements that haven't changed in a long time, I'm like, oh yeah, I wrote that. And the last time I didn't actually speak to him at all until he was on the podcast, it was really hard for me not to bring it up. But yeah, no, that's the story that was. So when you put the video out and then you start like over the week and you've shown me these messages, like seen these things, and I'm just like, yeah, that tracks with everything I experienced. Yeah, I mean, that's a perfect example of what eagle, in my opinion. I don't know what that is. Oh, Yigal, I guess. And sorry, I have to keep saying that. In my opinion, looking at all of this creates the pattern of somebody who just loves money, you know? Why would you patent something and then constantly, like, why would you stiff a college kid over like a couple $100? Exactly. It's all about money. He likes money. He wants as much money as possible. And I can say about the situation is, I don't have any animosity towards anybody. I would love to see sit down with Yigal one-on-one and see if we can find common ground. Okay, so now we finally have a statement that could be potentially, this is YouTube auto. Yeah. So, what is it? This is a statement that could potentially be defamatory. And what I mean by potentially be defamatory is that, like, it's at least a statement that has a fact alleged, and that fact is negative and, whatever. So, that is, at least we're at sort of the beginning on that. But the defamation on that is really, like, if you take this as untrue, and I don't know that that's, there's that real risk here. Because, I mean, why would somebody make that story up? But, I mean, okay. If you take that statement as untrue, what are the damages of ripped off a kid some 20 years ago? All right. So they say attached as Exhibit B is a list of defamatory statements. Okay, we're going to have to pull that up. I didn't pull that up ahead of time because why would you put that into Exhibit B? All right, so Exhibit B, we're just going to pull up here as their list of defamatory statements. Here we go. Alleged defamatory statements, of course, because this is all, this is all allegations and shade at this point. So, all right. Here we go. Exhibit B. Steve Sheraton says, ripping off technology that I invented 25 years, then I say it's not worth my time. I don't even know what that means. Can I have a crumb of context? There's a word for that. He's a patent troll. And stealing intellectual property that isn't theirs, then they go after any possible entity that might have something to do with the knowledge that's inside that pack. Okay, that could potentially, but again, you'd need some context here. And I find it interesting that they divorce this of the context. There's a word for that. He's a patent troll. Oh, wait. Refers to Yigal Masika using the term patent troll and defines these as people who fake intellectual property by stealing it. They're claiming it's theirs, and then they go after any possible entity that might have something to do with the knowledge that's inside that pack. Sean Boguina says, he's a magic terrorist, I believe. Okay, that's clearly opinion. That's not going to go anything. Patent troll is what I'd call him. I don't think that's going anywhere. Claims Yigal's patent application is exactly my rinky-dinky, implying his product is a copy. Okay, that sounds opinion. They play audio claiming to be voice of Masika, saying piece of shit device. Are they saying that's not Masika? Uses image of Masika's face. Wait, are they saying Masika's face is inherently defamatory? That sounds like the biggest self-own in the history of self-owned owns. Accuses Yigal of being Magic's biggest litigious bully, opinion, that for the last 3 days has been financially and legally bullying creators, opinion, into submission behind closed doors. I'm talking about Yigal Masika. Okay, none of that seems like it's gonna... Asserts the video will reveal just how sinister, manipulative, deceitful, greedy Yigal Masika really is. All of that is opinion. This is going to be backed up by facts. The facts might be defamatory. If today I'm bringing facts upon facts, okay. States that Yigal tried to patent it as his because he moved a hole onto the side, referring to Steve Sheraton's Rinky Dinky. Petty's video displays content from Steve Sheraton's video defaming Masika. Claims Yigal is now trying to sue anyone who brings out their own ring flights, even if it doesn't use a car key. And even though it's not Masika's in the first place, and even though he doesn't have a patent approved, and he never will. All right. So at least now we've got some actual stuff. By the way, if you were a law student, like, let's say I'm hiring for a first year law student, like I'm hiring for a first year associate, and I say, as part of your application, please add some writing sample of your legal writing, and you bring me a statement of claim where you don't get to the allegations of which defamatory statements until Tait, I've got it, we're going to get to it soon. You don't get to what statements are alleged to be defamatory until like page 22 out of 46, and it's attached as an exhibit. I am not hiring you. Like, this is not good writing. You should, when you read a lawsuit, the judge should not be reading it going, what's your point? What's your point? Because I'm reading this going, what's your point? What's your point? What's your point? Somebody says page 3, not 22. Let's go to page 3. Nope, page 3 does not. Page 3 does not do it. So I would be sitting here going, like, I was reading this going, what's your point? What's your point? What's your point? And that absolutely should not be where I'm at. I should be looking at this going, I know exactly why they're suing, and I should be like, there are limits to what you can say in a complaint, right? There are limits. But you can say a lot. You can do a lot on, like, information and belief and so forth. And if you write a complaint and it doesn't feel like I should be it doesn't feel like that you should be shaking the defense out for money by the end of it. Like, if you get to page 20, keep in mind, people start to tune out after like 10 pages. And so if you're not like, this person is super wronged and they should get all the money, then you have failed. All right. So what else do they say? The Craig Petty video has more than 26,000 views, while the Penguin Magic video has more than 7,834 views. Well, I can tell you, I am not doing this. Like, I'm not doing this video here because of the Craig Petty video. I am covering this because they filed a lawsuit, and I will probably get to more than 26,000 views on this one. So well done. They note these numbers are very impactful as the Magic community is not very large, such that the negative impact is overwhelming, such that plaintiffs' gross revenue has gone down over 60% since the videos were posted. Maybe that was a thing y'all should think about, right? Think about that when you're filing lawsuits. Because I feel like the attention you're getting is because of the lawsuits you're filing, not because of petty. I mean, to be frank, until somebody said, hey, have you heard that one magician is suing another magician? Have you thought about covering this? I had never heard of Craig Petty. I had never heard of Masika. So yeah, in these defamatory videos, Masika's name and image are repeatedly used, and numerous statements are made about Masika and plaintiff's products, including accusations that Masika is a patent troll. Sounds opiniony to me, that he files fake or fraudulent patents. Okay, there you could possibly get to something if you've got like a specific one. That Masika is a magic terrorist. That Masika, that's never going to go anywhere. That he bullies and intimidates creators. That's opinion. That Masika threatens lawsuits with no legal basis. Again, that's very much... There are multiple cases that say that, like, opining that somebody's case is bullshit is not actionable because people have to have that opinion. And there's a reason why. Like, if somebody comes to me and they say, hey, I want to file a lawsuit. Do you think this would be a good lawsuit? Can you write me a letter about whether or not you think this is a good lawsuit? What do we call that? We call that an opinion. I'm writing them a legal opinion. It's like, there is no like factual thing about whether well, I mean, sometimes there's a factual thing about whether a lawsuit is good or not, but for the most part, they are opinion. So plaintiff's products are copied from others, and the Masika copied products such as Rinky Dinky and other creators' inventions. Those statements are false. Well, that's you want to take that in front of a jury, okay? Plaintiffs have never filed a fraudulent patent, never knowingly misrepresented prior art in any patent application, and never used patents or patent applications to extort money from creators. As a direct result of these defamatory videos, they've received numerous messages from customers, colleagues, and retailers expressing confusion, concern, or hesitation about purchasing Masika products. Whereas my hesitation about purchasing Masika products, if I was really in the market, which I'm not so much, is that I don't like this lawsuit. So this is a suit about two magicians trying to make the other disappear. That is okay. That is the comment of the night there, Ranger. That's the comment to beat. That is awesome. So, all right. Let's see. The statements in the defamatory videos that plaintiff's products are exactly or nearly identical to Rinky Dinky, that Masika stole the idea, are untrue. Yeah, but that sounds opiniony to me as to what nearly identical means. All right. And why is this written in first person? The design mechanism and performance handling of my product. Why did this suddenly shift to first person? Weird. The defamatory videos also state or strongly imply that Masika threatened or bullied magician Mark Bennett and others by demanding $6 per unit, insisting that their products be pulled from the market, and using non-existent or imaginary patent rights to pressure them. Okay, so we have sort of the heart of the lawsuit here. Let's move on and look at the response. Because, yeah, the response is fun. So here we go. So by Marc J. Randazza, Alex J. Shepard of Randazza Legal Group. All right. So to the courts, please take note that all of this will be heard. And statement of compliance. I think this is the same document here. Yes. All right. So we got citations. All of this is nicely laid out. All right. Introduction. Yigal Masika is a magician who has a long-standing reputation for stealing other magicians' tricks and using patent law illusions to try and eliminate and intimidate his competition. For his next trick, he wants to make the First Amendment disappear. Yes! The This is much better writing because already, A, I'm amused because we've got some clever wordplay here about patent law illusions and making the First Amendment disappear. But already, paragraph 1, I know where the defense is I know where this is going, which is I am making a First Amendment argument and the other side is a piece of shit. It took like 23 pages for the other side to start getting to where they were going. And here I have an idea of that first paragraph. Law students, for the love of God, when you're working on like your things, look at this kind of writing because it might be a little cheeky for some judges, but it's good. And the thing is that even the judge who's like, that's cheeky, is going to be sitting there going, and they're going to have a little smile, right? They might be like, they might be sitting there going, oh, I don't know if that's proper, but they're still going to be like, but it's funny. He has learned that often defendants will pay him off rather than find themselves bogged down in litigation. Usually those lawsuits are for weak patent infringement claims. Now he's trying to silence discussion of his abusive litigation tactics, but the First Amendment is more robust than that. His complaint has all the telltale signs of a SLAPP suit. He's amended once, amended twice, and yet it is still almost impossible to even tell what statements he's suing over. Yes! Like, defamation suits, when they are properly done, will state, here are a few specific phrases that I'm alleging are defamatory. And so, like, I have seen one where the person, so this guy got accused of being a PDF. And the reason why that bothered him is because it caused like his business to shut down because he taught kids and somebody accused him of being a PDF. And so that lawsuit, which was a well-written lawsuit, started off with, plaintiff is a child educator, blah, blah, blah. He is respected in his community. Notwithstanding the fact, defendant uttered the following statements. Statement 1, Statement 2, Statement 3. These statements were all untrue. And they were, and it's like, all right at the beginning, I know why, I know what statements are being alleged. I know why the plaintiff is so pissed. And okay, we're off to the races. The more a legal filing has to play like a shell game where they won't actually tell you what the issue is, the more likely it is to just be bullshit and hurt feelings. And I have a big sad, but not I have a good legal claim. When you have an excellent case, you lay it out, right? When your case is great, you put it forward. When your case is shit, you write in this meandering, distracting kind of way. So the second amended complaint should be dismissed independently because it is a shotgun pleading that fails to give a clear statement of what he's complaining about. Yes. Nevertheless, Craig Petty has done the work of sifting through the box of used pinball machine parts to define what Masika wants censored and punished. And all that comes out is that Masika does not want people sharing negative opinions about him. This case must be dismissed with prejudice, with costs and fees awarded under the California anti-SLAPP law. This is part of why I go, why the ever-loving fuck did he sue in California? California. Blows my mind. Because California is one of the worst possible jurisdictions for this. And like if Craig Petty's in the UK, Why not sue him in the UK? A, you'd prevent Randazza from being on it. B, California's got one of the nastiest, strictest, meanest anti-SLAPPs around. And so you're like, I want to just, it's bizarre, right? It's absolutely bizarre to me. It's like those movies where the aliens invade and they decide they're going to conquer a planet and they decide to conquer Earth, and yet they're vulnerable to like water or the flu or like nitrogen atmosphere or like whatever. And so it's like they're specifically invading the place that is going to, to kill them most. Factual background. Yigal Masika's broad and poor reputation. During the meet and confer, Masika's counsel adamantly insisted that his client was not a public figure. That's going to be a tough sell. Zealous advocacy may require an attorney to take difficult positions, but there does come a point when clinging to a position that is so unsupportable becomes something different. We're at that point here. Masika pleads his way into public figure status. Plaintiffs have developed a fine reputation and goodwill at a substantial expense in regard to their loops products. Plaintiffs' products had a strong reputation in the magic community and generated consistent sales across multiple dealers and online platforms. That should be enough. It's always lovely when you can use the other side's pleadings to beat them with. So, but, well, and the other thing is that Masika, from his own pleadings, did an interview where, like, he's doing podcast interviews about his magic. And if you're the sort of person who is doing public interviews about your magic, then you are almost certainly a public figure, at least with respect to the magic, right? But given Masika's stubborn refusal to admit something so clear, Petty has been compelled to gather and provide judicially noticeable proof of his public figure status. See accompanying request for judicial notice. Masika is featured on the cover of Vanish, an international magic industry magazine. One of his products was featured in a Golden Buzzer Act on Britain's Got Talent. He's performed at prominent magic shows internationally. He's lectured globally on magic tricks. He's appeared in various documentaries, podcasts, and magazines about magic. His tricks have been performed by celebrity magicians and on popular TV shows. Magic retailers worldwide sell his products. Several magicians have reviewed these products with hundreds of thousands of views. He may not be as prominent as Penn and Teller or David Copperfield, but he's certainly just one tier below them in the magic industry. All right, that's a pretty strong statement, right? By the way, one of my claims to fame is that I have been called a loser by Penn Jillette. So, yeah. And somebody's going to be like, what is the context for that? I will explain later. Masika's reputation isn't all that good, though. It took a turn some years ago when it became apparent that he was stealing ideas from other magicians and then trying to use litigation to silence those who complained. On April 5th, the inventor of the Rinky Dinky device, maybe I'll make that as a goal. Okay. I'm going to set as a goal here. I will set that as a goal. The goal is explain. All right. So Steve Sheraton published a Facebook post showing that Masika's ring flight device at issue in this case is extremely similar to Sheraton's 2001 product. In response, magic inventor João Miranda posted that Yigal Masika threatened me with lawyers when I released my gravity reel. He's a true bully. He lost all the respect I had for him. Funny in a bad way to see he copied your original invention. In June 2024, a magician in the Magicians Only Facebook group stated that Masika is a thief of ideas, and he doesn't bring anything to the table as far as advancement in the art, and he is a bully. In the same group, shortly before petty statements were published, magicians discuss shenanigans around Mark Bennett's air flight invention and Masika's pending patent application, with one member stating that nothing Masika has released is original to him, but rather a variation of something someone else has created. None of this stuff is an original concept, and if everything he's made a variation of had patents, he'd have nothing. What a joke. The commenter then says, this invention was created and sold many years before Masika's ring flight, and he's trying to patent his as original and say others can't release their variations. So I just also want to note here, there is a real, there's a certain thing where, like, I'm a litigator, right? I do criminal defense. Criminal defense is done in Canada, at least, almost entirely. You just go to trial and you argue things at trial, right? There's a lot less motions practice. But when you have a file and you're a litigator, what you're going to do is you're going to look at that file and you're going to be anticipating what the evidence might look like. And so some of the things I think about when I think about that is I think, well, what witnesses am I going to have on my side, and what witnesses are they going to have on their side? And doing criminal defense, often the list of witnesses for my side is nobody, but you still have to think about that. You know, what are the other side's witnesses? And in this, one of the things I really like about what Randazza is doing here is he's like, look at all of these people we could potentially bring to a trial if it goes to a trial, if the anti-SLAPP is not, not accepted. But if this goes to a trial, imagine this trial. You've got Masika there saying, I am a great inventor. And then you're going to have this lineup of magicians who fucking hate him. And magicians are charismatic people. If you saw the Afro Man trial, one of the takeaway lessons from the Afro Man trial is think very carefully before you sue somebody who is more entertaining than you are. Because, like, Afro Man is funny. And the lawsuit just ended up being a giant embarrassment for all the people who sued Afro Man. Here, they're going and they're dealing with a bunch of charismatic people. Being a magician is fundamentally a charismatic, it's an exercise in charisma, right? If you meet magicians, and I haven't met many magicians, but I've met a couple of them, they're very much good at people because you have to be. First of all, a ton of magic is about charisma, right? You need to have the charisma to point people's attention here while you do something over here, right? And you got to do that with 1,000 people. You got to make sure they're all seeing this while you do this, right? And the other thing is you have to put on a show. Because if I just got up here and I was like, hey, look, I'm going to show you a trick. I'm going to, make this thing disappear and like, it's gone, right? It's not a good trick. But it's also not a good delivery of the trick, right? You got to have patter. You got to have, you got to get people engaged. You got to all of this stuff. And I'm like, he's going to have, this could end up being the greatest trial of all time, because imagine you're sitting there and it's like, you're going to have magicians going up and showing off their tricks that they say are similar. Like, this is a disaster in the making. even if, like, if you're reading this and you're like, okay, I think I can survive the anti-SLAPP, you still really, really, really don't want this to go to trial. So one of the members, after noting the conspicuous similarities between Masika's invention and the Rinky Dinky, says to try and patent something you stole to begin with is insane. Then to try and tell people they can't make variations when yours wasn't even a variation, but actually a complete riff-off is, again, insane. Now, this also matters for defamation, because if his reputation is already as a thief, then there's nothing to sue over, right? So, yeah. Masika's customer base has also expressed these criticisms about the specific invention at issue here. On the Vanishing Incorporated website, which offers Masika ring flight for sale, there's a community questions forum in which customers state that Masika's invention is a ripoff of the Rinky Dinky and that its advertising copy misleads customers by implying that it's Masika's original idea, with one person saying Masika's invention could easily be considered blatant theft. Magicians David Penn and Paul Longhurst published a YouTube video in April 2024 reviewing Masika's ring flight, noted his claim of patent protection, expressed confusion about this because he did not come up with the idea, and mentioned prior iterations of the concept. Masika is not just a famous magician, but is famous for being a litigious bully and a thief. This is the other thing about filing a lawsuit, right? Let's imagine that people are saying shitty things about you, right? And so you sue them. We don't have the David case on the thing, but let's say people are saying nasty things about you. You sue them. Okay, well, now you've pulled them into litigation, and now you've pulled them into the world of litigation privilege. Litigation privilege allows you to say all sorts of things about people without being sued for it. So, to be fair, maybe he's not a thief. This case is about whether he actually stole or is not about whether he actually stole all the inventions and ideas that everyone says he did. But maybe this is all deeply unfair. Maybe everyone just says that. But that was his long-standing global reputation before Petty said a word about him. And to sue someone in a clear slap suit for calling attention to the fact that he's a reputation as a litigious bully by calling him a litigious bully, that seems to prove the point. You can't sue somebody out of a reputation, out of an allegation that you are a litigious bully, because it just, yeah. All right. The videos at issue. This case arises primarily from a July 14th video Petty posted on his Craig Petty's Magic TV YouTube channel titled The Desolation of Yigal Masika. This video is over 3 hours long and features interviews with multiple members of the magic community. The gist of the video is that Masika has a pattern of claiming patent protection for commonly used devices or methods used in magic tricks, then suing or threatening to sue for alleged infringement of these dubious patents. It is primarily focused on a dispute between Masika and the magician Mark Bennett, with Masika having filed a patent application, which is still pending, over a ring flight device and claiming that Bennett's allegedly similar air flight device is infringing. Petty mentions that Bennett disagreed with his claim of patent infringement. Petty interviews Bennett from 23:40 to 1 hour and 13 minutes. The two discuss at length how his and Masika's devices are distinct and that Masika's claims of novelty are suspect, that Masika's claims of infringement are based on a pending application rather than a registered patent, and that Masika made statements which Bennett interpreted as threats of litigation if Bennett did not agree to remove his device from stores or agree to a $6 per unit licensing agreement. And they note here, throughout the video, Petty repeatedly expresses his opinion that filing a patent application provides no legal rights in the claimed patent. In general, Petty is correct about this, as the Patent Act only speaks of providing patent protection to patentees rather than applicants. But even if he were wrong, Petty discloses that he's not a lawyer, thus making it clear he's not making objective factual statements. Further, it is not defamatory to make wrong statements about the law. And even if it becomes so, we are going to need to either double the size of and if it becomes so, we're going to either need to double the size of the federal judiciary, expect 10-year delays to get to trial, or close down all social media forever. I love the writing. Bennett states that, based on his own experience, Masika is trying to prevent any other ring flight devices from entering the market for the foreseeable future, thus ending innovations for this type of magic device. Bennett says that he has been threatened and bullied by Masika in this dispute. Again, that really sounds like opinion. Bennett and Petty discuss that Masika doesn't disclose the name of the rinky-dinky device's inventor on the patent application, despite that device being the obvious inspiration for Masika's invention. After the interview, Petty discusses specific differences between Masika and Bennett's inventions and notes that the timeline of events makes it very unlikely that Bennett was copying Masika's invention because, for example, Masika apparently released his device several months before filing his patent application. After showing the interview with his primary source, Petty discusses the next step of his research, seeking comment from Masika himself. They note here, this is an integral part of Masika's defamation claim, but only because he materially misrepresents Petty's statements. Neither Petty nor anyone else states that Masika did not disclose Rinky Dinky or Ring Flight Revolution as prior art in his patent application. Rather, they state that Masika did not give credit to the inventors of these devices, which is literally true. Masika's patent application does not name these inventors. Later, Petty plays a voicemail from Dave Bonsall, the inventor of Ring Flight Revolution, and the leading expert on ring flights, to Mark Bennett. In it, Bonsall says that he's impressed by Bennett's development on the ring flight technology and his new invention, which Petty considers a strong indicator of Bennett's device not being infringing. At time, Petty describes Masika's trick as, in instance, a real design for ring flight in a key, which is the same thing as Bonsall's Ring Flight Revolution. All right. So, he provides the full unedited text message exchange between himself and Masika regarding this dispute, along with his commentary on how Masika's claims of novelty are unfounded due to being based on pre-existing methods. In this exchange, Petty brings up Bennett's claim of a $6 per unit requested licensing fee, which Masika does not dispute. Sometimes silence can be considered an admission. And so where is that circumstance where silence can be considered an admission is when somebody confronts you with a fact where you would be expected to dispute it if it was something that was not true. Then that can be relevant as, potentially as evidence. Yeah, we're not talking about David Gingras at this point. We could talk about Gingras on another stream. Right now, we are talking about two lawsuits where Randazza is on the side of justice, in my view. So, all right. Petty mentions he told Masika it'd be fine with Masika providing a public statement on this dispute that Petty would include in his video. Petty then moves on to discussing the rinky-dinky device, which is nearly identical to Masika's claimed invention. Petty mentions he found a Facebook video posted by Steve Sheraton, the inventor of Rinky Dinky, in which Sheraton... Can I just say I hate Rinky Dinky as a product name. Why did somebody call a product Rinky Dinky? I've had to say Rinky Dinky like 600 times, and I just hate it. Dry. I believe that's dry vermouth in my... now I'm second guessing myself, but I'm pretty sure it's dry. All right. In which Sheraton provides a side-by-side comparison of Rinky Dinky and Masika's claimed invention, showing the two are extremely similar, and invites the viewer to come to their own conclusion about who copied whom. He then interviews Sheraton, who expresses frustration that the advertising copy for Masika's ring flight invention made it sound as though he came up with it by himself, when in fact it was an iteration of the Rinky Dinky. We're just going to call it the RD from now. At Time, Sheraton displays Masika's patent application on his phone and says, "My God, you look at it, and it's my RD. It's exactly my RD. It's hilarious." Sheraton says Masika is a patent troll. Petty expresses his fear that people who are weaponizing patents will stifle innovation in the magic community, and that Masika's pattern of IP enforcement appears to be a way of generating income, and Sheraton expresses the opinion that Masika is an unethical bully. Unethical is another one of those things where where it's a statement of opinion in most cases. So, all right. At Time, Petty discloses that Masika threatened to sue João Miranda, a prolific inventor in the magic community, quoting his written response to Masika's allegations of infringement. Miranda refers to Masika as a bully for his tactics of threatening baseless patent litigation that stifles creativity. At Time, Petty shows in a portion of an episode that the Magic Insight podcast featuring another magic inventor, Sean Bogunya. Bogunya leads off by calling Masika a magic terrorist and a patent troll, and one of the hosts calls Masika a bully. Bogunya recounts an experience from 2009 where Masika sent a cease and desist letter over a video Bogunya posted online displaying a magic trick. This is the other problem with defamation suits. Because if you file a defamation suit, one of the things you put into the public record as a subject of dispute, is your reputation. So you put your reputation as a contentious matter in a lawsuit where people are able to file things with litigation privilege. And what this means is that people are then going to be able to file things talking about everything you do that sucks. Every little bit of every awful bit of reputation damaging anything gets to come out. You really think that's worthwhile? You think it's a good idea? Think again. Defamation lawsuits are terrible ideas. So both Bogunya and the hosts mentioned that there were many stories of Masika threatening magicians with infringement lawsuits. At Time, Petty plays a voicemail that Masika left for Bogunya, in which Masika calls Bogunya a clown and says he is messing with the devil, and that Bogunya will be a big loser with your piece of shit device. Petty discusses another magician, Tom Wright, who received bullying and intimidating communications from Masika in response to a device Wright released, in which Masika demanded that Wright take his product off the market because it was allegedly copying one of Masika's devices, despite their respective devices using a different technology and methods. Petty shows a recorded message from Wright in which Wright discusses the threatening call from Masika, that by this time he had sold the rights to the device to a magic shop, and that Masika gave up on pursuing any claims of infringement shortly afterwards. It's all of this is basically saying he's got a terrible, terrible reputation. In his conclusion, Petty discusses how the idea of somebody patenting a ring flight is ridiculous, and that if one were to obtain such a patent, it would stifle innovation within the magic industry. He says repeatedly that he is publishing this video to bring attention to the fact that Masika is attempting to stifle creativity so that he can leave the magic community in a better position than he found it. And he constantly states throughout the video that he's expressing his opinion about Masika's conduct. Masika also seeks to stifle Petty from talking about this lawsuit. Petty published a YouTube video about this case on February 13th titled "Sued for Speaking Out." Petty says that he stands by his opinion expressed in the Desolation video that Masika's magic's biggest litigious bully for the last 3 decades, and calls him a patent troll who uses the courts to bully people into submission. He claims that Masika is using litigation to silence free speech, and points to this very lawsuit as evidence of Masika being a litigious bully. Petty also says he is starting a crowdfunding campaign for his legal defense because his legal fees will be high, and bullies know how to run up a tab. True, right? Finally, Petty published a third YouTube video titled "Crowdsourcing Information for the Masika versus Craig Petty Slap Suit," attached as Exhibit C. While plaintiffs do not appear to claim this video contains any actionable statements, they complain about it nonetheless. Part of what they're complaining about, I think, seems to be what they really don't like. It seems like they don't like that he's raising money to defend himself. Because that's a big, if you're trying to bully somebody, which is what the allegation is, you might not like that they're raising money to defend themselves. In the video, Petty notes that Masika is making the ridiculous claim that he's not a public figure and asks his viewers to provide evidence rather than having his legal counsel do extensive research of Masika's public figure status to cut down on litigation costs. So, since Masika should be paying Petty's fees in the end here, he should be somewhat grateful that Petty has crowdsourced some of his research rather than paying his lawyers to do it on an hourly basis. Oh, damn. That is spicy. I like that. Legal standard. When the movement makes a prima facie showing that the suit arises from an act in furtherance of his right to free speech, I think we're there. He satisfies prong 1 of the anti-SLAPP law. As relevant here, the statute protects any written or oral statement or writing made in a place open to the public or public forum with an issue of public interest. The defendant's burden at this step is not a particularly demanding one. Then the burden shifts to the plaintiff to demonstrate a probability of prevailing on the challenged claims. In federal court, this second step of the analysis uses either the standards for deciding a motion to dismiss or Rule 56, depending on whether the motion makes a legal attack or factual attack on the operative pleading. This motion is brought as a 12b6 motion, so a legal attack. The court is well acquainted with the plausibility standard under Ashcroft versus Iqbal and Bell. Iqbal basically sets out sort of pleading requirements, and plausibility is you can't just claim anything, right? It's got to actually be believable. So a court, like if you allege that somebody like turned into a werewolf and attacked you, that would not be believable, right? They note a court may take judicial notice of matters of public record without converting a motion to dismiss into a motion for summary judgment. And through the incorporation by reference doctrine, the court may consider a document not attached to the complaint if the plaintiff refers extensively to the document or the document forms the basis of the plaintiff's claim. All right. Argument, anti-SLAPP. Plaintiff's claims rise from protected activity. First anti-SLAPP requirement is easy. Petty statements were published in YouTube videos, and YouTube is a public forum. Note that they cite to Cross versus Facebook, Lacoste versus Keem. So, yes, YouTube is public. Issues of public interest is defined very broadly as any issue in which the public is interested. Okay. The issue need not be significant to be protected by the anti-SLAPP statute. It is enough that it is one in which the public takes an interest. No subject are off limits, as even social or even lowbrow topics may suffice. And note that when they've been defined, like when they've been asked to decide what public interest is, like where does public interest start? Well, public interest is actually a pretty low bar. They've said that like hundreds of people, there's case law that states that hundreds of people can be public interest. And so, if hundreds of people can be public interest, 29,000 can be public interest, right? Okay. What is the public? The public is you and me. The fact that we're watching this and people are interested right? We are an hour and 40 minutes into this case. There are 1,600 people watching. That is the public being interested, right? And like 1,600 people watching a thing where we're going through legal filings and breaking them down is actually kind of exceptional, because most people find legal filings to be as interesting as, paste. This is something that's interesting people. There is a public interest which attaches to people who, by their accomplishments, mode of living, professional standing, or calling, create a legitimate and widespread attention to their activities. So the California Supreme Court found that picketing a local land developer, even when arguably animated by a personal grievance and attended by only a few dozen people, satisfies the first prong when outside observers would view their speech as relating to the broader issues of inadequate housing and foreclosures. All right. Speech here relates to Masika's reputation within the magic community and his pattern of using his influence to bully smaller members of that community with threats of litigation stemming from dubious claims of patent protection. If you want to have a good reputation, you've got to do good things, right? That's kind of a key thing there. Hi, Runkle. I've watched you since Johnny Depp. I just wanted to say that I finished law school this past week. Congratulations. No articling yet, but you've made me super interested in criminal law. That is amazing. So congratulations. So I am, yeah. All right. The Desolation video contains interviews with magicians who specifically call Masika a bully and patent troll who has ripped off their inventions or claimed patent protection over unpatentable or unprotectable elements of magic devices. Petty specifically says in the Desolation video that he's publishing it to bring Masika's abusive behavior to the attention of the magic community, so the community might stop Masika from stymieing innovation. I'm not sure if stymieing is spelled correctly there, but I'm not certain. Through abuse of patent law. While the magic community may not be large, it is global, and Masika's conduct is of significant interest to every member of it. Masika himself pled that 29,000 people watched it. So if 29,000 people were interested, that seems to me to meet the standard. All right. The libel, trade libel, and false light claims fail. So the elements of a defamation claim, we are at 8 out of 10. We got 2 minutes left. People want to hear the story, I hope. So hit that goal. We got 2 minutes left. All right. Libel, trade libel, and false light copyright claims fail. So elements of a defamation claim are 1, a publication that is false, or a publication that is 2, false, 3, defamatory, 4, unprivileged, and 5, has a natural tendency to injure or causes special damage. If the plaintiff is a public figure, they must prove with clear and convincing evidence that the defendant published with actual malice. Actual malice, by the way, is where most defamation claims against public figures fail, because it is very difficult to establish actual malice. Actual malice is actually quite challenging, because it's either that you knew that what you published was false, or you published with reckless disregard for the truth. And what is reckless disregard for the truth? Well, in one case that we previously covered on this channel, that was the, the Taylor Lorenz case. Actual malice was enough to survive the motion to dismiss on the basis that the person themselves who had published the statements expressed a claim, like expressed themselves that they thought that the statement was probably false, and then they published it anyway, right? But if you have to have something like that. Masika has failed to plead a plausible claim. So 1, the statements are not of and concerning Masika Magic, i.e. the corporation. It's about the person. For a plaintiff to bring a defamation claim, the statements at issue must identify the plaintiff by at least clear implication. None of the statements at issue are about Masika Magic. They all refer to Masika personally. Masika Magic thus cannot assert any claims against Petty based on the statements in his videos. Right there, the case by Masika Magic must be dismissed and costs and fees imposed. But then you've got Masika personally, right? So, what is it? The statements are true or substantially true. The statements about Masika personally are not actionable for multiple reasons. First are the true statements. A statement must be false to be defamatory, and minor inaccuracies do not amount to falsity so long as the substance, the gist, the sting of the libelous charge be justified. I like that quote. I love that one. So a statement is not considered false unless it would have a different effect on the mind of the reader from that which the truth would have produced. Masika alleges in the Desolation video, Petty states, "You didn't even credit the person that most people would consider to be the godfather when it comes to ring flights." And he specifically claimed that Masika never mentioned Dave Bonsal's ring flight revolution or Steve Sheraton's rinky-dinky device. These statements are literally true. Masika's ring flight patent application doesn't mention the names of these inventors, only the names of the devices. Also, they're suing Petty, right? If they're suing Petty, they need to show that Petty either intentionally lied or acted with reckless disregard. How are you going to land that he was like in reckless disregard for the truth when he literally has magicians on his channel, on his podcast, saying the things, right? Is it not? How can you say that he has reckless disregard for the truth when he's got the people there and like, because literally I believe those people becomes a complete defense. So, what is it? Petty states at thing as part of a discussion specifically about Masika's ring flight patent application, not over his overall patent portfolio. It is undisputed that Masika does not have a patent registration for this device, and predictions about future events cannot be defamatory. Okay. It is literally true that many of Masika's patent applications have not proceeded to registration. Of the 32 results returned for a search of Yigal Masika on the USPTO's patent search tool, 19 are mere applications that did not mature into to registration. So, very few is a fair characterization of the minority of attempts that proceeded to registration. Masika alleges that Petty further republishes and ratifies Sean Babunya's false claim that Masika's patent was bogus because he didn't list any prior art of any kind. Plaintiffs are being disingenuous. Sean Babunya's statements in the Desolation video were about an entirely different patented issue in Masika's 2009 lawsuit against him, which Masika dismissed, and there are no factual allegations that this earlier patent was anything other than bogus. Yeah. Statements are opinion or rhetorical hyperbole. A statement of opinion cannot be defamatory. This is like basic defamation stuff, right? In another lawsuit that I covered, I noted that calling somebody a TERF could not be considered defamatory because what counts as a TERF, in the same way that what counts as a bigot or a racist or whatever, is going to be a matter of opinion. When the speaker discloses the facts on which their opinion is based, they can only be liable if the disclosed facts themselves are false and defamatory. When the facts underlying a statement of opinion are disclosed, readers will understand they are getting the author's interpretation of the facts presented. They are therefore unlikely to construe the statement as insinuating the existence of additional undisclosed facts. The courts have consistently held that when a speaker outlines the factual basis for his conclusion, his statement is protected by the First Amendment. Such speech is protected no matter how unjustified and unreasonable the opinion may be or how derogatory it is. A statement is less likely to be viewed as factual when it is cautiously phrased in terms of the author's impression. The identity of the speaker is also important in determining whether a statement is actionable. So, and C. Franklin, finding it significant that the author did not purport to be a lawyer stating opinions in legal truths or as legal truths in legal verbiage. Further, the predictable opinion doctrine asks whether the statements were made by participants in an adversarial setting in which the audience may anticipate efforts by the parties to persuade others to their positions by use of epithets, fiery rhetoric, or hyperbole. In such circumstances, language which generally might be considered as statements of fact may well assume the character of statements of opinion. So they're talking about for MSNBC host Rachel Maddow to exaggerate the facts and call OAN Russian propaganda was consistent with her tone up to that point, and the court finds a reasonable viewer would not take the statement as factual given this context. Masika complains about Petty stating the design of your ring flight is not yours. It's Steve Sheraton's. You moved a hole. And that Masika's invention is identical to Rinky Dinky. Petty is not alone in this opinion. Steve Sheraton, the inventor of the Rinky Dinky. I'm going to have to buy a Rinky Dinky, aren't I? Now I'm just... I'm not going to want to search this, am I? Okay, that... I'm just getting the children's song. I got to add magic to that. Oh, look, it's available on Penguin Magic. Cool. $51. Okay. I will have to... I might have to buy these and like try to figure them out and look at them and see what the differences and similarities are. Also, when I do my taxes later next year, because I already did them for this year, but when I do my taxes next year, I am going to potentially have to deduct a Rinky Dinky as a business expense. And that I hope I don't get audited is all I'm going to say, because I'm going to have to explain what that's about. So Steve Sheraton, the inventor of the Rinky Dinky, displays the patent application on his phone and says, "My God, you look at it and it's my Rinky Dinky." Out of context, that statement is it's exactly my Rinky Dinky. It's hilarious. Even if Masika disagrees with Petty's conclusion about him moving a hole, this is an opinion based on disclosed facts, namely the specifics of the ring flight patent application. Anyone can look at the application and come to their own conclusion. So Masika complains that Petty calls him a patent troll, a patent terrorist, and a magic terrorist. But then the second amended complaint descends into a morass of confusion. It seems that plaintiffs then allege that defendants, without specifying who or in what videos, state that Masika files fake or fraudulent patents, that Masika is a magic terrorist. Magic terrorist sounds so much cooler than what they're talking about here. It's like, all right, that Masika bullies and intimidates creators, that Masika threatens lawsuits with no legal basis, that plaintiffs' products are copied from others, and that Masika copied products such as Rinky Dinky and other creators' inventions. He also alleges that unspecified videos state or strongly imply that Masika threatened or bullied magician Mark Bennett and others by demanding exactly $6 per unit, insisting that their products be pulled from the market, and using non-existent or imaginary patent rights to pressure them. And they note these are Sean Begunia's statements, not Petty's, and Begunia only called Masika a magic terrorist and a patent troll. All right. These are all statements of opinion based on the same disclosed facts, specifically the extensive discussions about the weakness of Masika's claim of patent protection and interviews with multiple magicians who have had bad experiences with Masika and accused him of being a bully and a patent troll for his behavior. Masika is free to disagree with these opinions, but he does not allege that any of the underlying facts are false, meaning these statements are not actionable. While the SAC second amended complaint alleges that Masika never made the cited demands of Mark Bennett, he never refuted or even mentioned these demands when Petty requested pre-publication comment from him. How is it supposed to be reckless disregard for the truth when he's asked for a comment about those statements and he has no comment? Right? He never denied it. He never even denied it. Amanda, not yet. I'm getting closer to nailing a place down. I'm going to call them after the stream. So, all right. So they note further, a statement expressing an opinion about the patentability of an alleged invention is not actionable. So they cite two things, finding plaintiff is a problem for the industry due to sending patent infringement demand letters, and the plaintiff was pursuing frivolous lawsuits for protected opinion. The frivolous lawsuits thing has long been considered like protected opinion. All right, so in the Sued for Speaking Out video, Petty says that he stands by his opinion that Masika is Magic's biggest litigious bully for the last 3 decades. He's a patent troll. He uses the court to bully people into submission. All right. And this is the other one. And is someone who's trying to legally silence me by playing a game of who's got more money to burn. Literally what is going on here is that Masika appears to be going on his greatest trick. And his greatest trick is watch me make this pile of cash disappear. And oh, look, it's reappeared in my lawyer's wallet. And now watch him turn that cash into a yacht. This is not the sort of magic trick, though, that people will pay money to see. It's all right. So skipping ahead a little bit here, plaintiffs are public figures. I think this one is kind of obvious that Masika is a public figure. He disagrees with it, but I think that his disagreement is kind of weak. Plaintiffs have not even plausibly alleged actual malice. I agree. I didn't see anything looking like actual malice or even recklessness. So I'm going to be interested in this one. I'm not sure exactly where it's going to land, but I am let's just say I think that I think it's got a pretty good chance of getting nuked from orbit. Let me just see. I gotta find, where did I put that? Here we go. Let's see. There we go. So right now we are waiting. The motion to dismiss the anti-SLAPP was filed May 1st. So we'll have to see. They're going to make a response. We'll see what their response is. And yeah. Pashan says, I hope it goes to court. Let's shake up the magic industry. I hope it gets defeated with the anti-SLAPP, honestly. Because if the anti-SLAPP goes through, it will it'll probably encourage innovation within the magic community. So in an anti-SLAPP action in California, yes, if the anti-SLAPP is successful, the defense gets their attorney's fees paid. And that's going to be a whole pile of money. So there's a reason why people don't bring these claims lightly, because it can end up costing a ton of money. All right. So I promised you guys a story. You hit the goal. We're going to tell you a story. So once upon a time, Mrs. Runkle was maybe going to go to Mars. And what I mean by that is that there was a program, Mars One, and the idea is that they wanted to send people to Mars on a one-way trip. They wanted to have people like volunteer to try out to be Marsstronauts. And so they put out an application, and they got something like 100,000 applicants. I applied. I did not go to round 2. Mrs. Runkle applied, and Mrs. Runkle was one of a much smaller group that got approved to compete for round 2 of the Mars 1 project. Now, Mars 1 ultimately fell apart because what they were hoping to do is they were hoping to basically fund the Mars project off of like reality TV shows, right? They wanted to like televise the contest for people trying to become on the trip and so forth, and ultimately they couldn't get the funding together, so the project collapsed. But she was on that list for, second person, and yes, one way. So for a while we had reporters in our living room. We had all of these things, and she got interviewed by Penn Jillette. Penn Jillette interviewed my wife for his podcast. And Penn Jillette was like, so what's your husband going to do if you leave? And she's like, he's going to stay behind. And he was like, did he apply? And she's like, oh yeah, he applied, but they did not take him for the second round. And Penn Jillette laughed and was like, loser. So that is the story of how Penn Jillette called me a loser on his podcast. I want to go and actually find that podcast and, find that podcast and, what do you call it? Clip the loser thing and use that as an audio clip. What is it? Penn interviewing a future potential astronaut. That seems kind of odd. Only if you don't know Penn Jillette and his interests. That is absolutely in his, absolutely in his interest there. So, yeah. Did I lose sound? I see some people saying muted. Am I still, can you hear me? Thumbs up, thumbs down. Yeah, okay, that does sound like Penn Jillette. Okay. All right, so Tait can't hear me, but everyone else can. Cool, awesome. All right, so yeah, I think that is this is an interesting one. But that is not the end of stuff that Randazza is on. And the interesting thing is that the next one we're going to look at, and I should set new goal. I'm trying to do fewer drink-related goals, but I'm going to do at least one. We're going to... So, there we go. All right. So, we're going to... what is it? Ty doesn't want to hear that you volunteered to die in the void. I mean, everybody dies somewhere. Dying on Mars would be badass. A lot of people were like, hey, why would you let your wife go to Mars? And it's like, A, you don't let your, wife go to Mars. She gets to make her own calls. But B, it's like, wait a minute. Your wife has the opportunity to do something freaking historic. Absolutely you would, because if you so really don't come back. It would be you go to Mars, you live the rest of your life on Mars. But if you go and set up, if you're the first person to be a Mars colonist, you're going to have a plaque there for the rest of time, right? They're going to, kids will learn your name in school books. And people are like, what would you do? And it's like, well, I'd be sad. But also, I would have Mrs. Runkle sign everything. Everything. She would sign everything before she left. So my retirement plan would have been selling, like, this toilet paper holder signed by one of the first Martians. So, yeah. All right. Let's cover super chats before we move on here. It's me, Tony P. Thank you so much for 10 gifted memberships. Masterful Melon, Woot, number 16. Thank you for being here. Miss Erica Claus, Monday was a fun day. Great company tonight. Thank you for being here. Girl named Joey, hope you're feeling better tonight. I am feeling all right. Wildcats 28. We need a Runkle take on the Star Witness and the Stefan Diggs trial, because holy cow. I only watched parts of it, so I don't really know I don't really know all that much. We need a Runkle take. James Lynch, welcome aboard. And thank you for the gifted membership as well. Much appreciated. Honk Banana No. Tonight's Honk Banana No is brought to you by Aunt Beru's Blue Milk. 4-ounce coconut milk. I'm out. 1 ounce cream. 3-ounce blue Caraco. 2-ounce coconut rum. Shake with ice. Straight into glass. Call out Luke. Luke. And serve. I am not a big fan of coconut drinks, so I would be out on that one, but you have fun. Suzanne D, keep enjoying the martini. I'm enjoying what I think Penguin Magic should refer to. Against the Tide, please like to help Runkle reach his pro bono goals. Yes, my goal is to open up a free law firm. So, yeah. Mildred Katie says, live stream tonight, birthday tomorrow. That is awesome. So, happy birthday. Yeah. There's such a delay in communications. It would be hard to have a conversation on radio. It would be a matter of like email conversations kind of thing. So, yeah. Good Tribal Studios. Thank you for being a member. Marvin CZ. Martini is good. Martinis are good. Thank you for 10 gifted memberships. The only problem with martinis is you can't have many of them because they're like 2 ounces of booze. And yeah, they're huge. Marvin CZ, now really 3 years. It's been a great time, Ian. It's been a great time. Harbinger of imminent death. I want to see magic tricks in the courtroom. If you're under checks again, you'll see that my motion is already granted. You're in contempt. I mean, this actually might, if it goes to trial, there is a legitimate reason for the court to see magic tricks. The jury could actually see multiple witnesses putting on multiple magic tricks and then explaining the magic tricks. I mean, this will be the luckiest jury on the planet, because usually juries get to see like murder photos or 600 boxes of fraud evidence or, yeah. Brentwood Chic, thank you with the glasses clinking there. Law-abiding rebel, cheers, cheers. None left. Reminder, don't tell the internet what you hate. For example, Runkle hates super chats. Love it. Mostly void, partially stars. Hi, Chat and Runkle. Hello. Splaw, get that martini in you. It was a good martini. Elf Wiggins says, tossing money in your digital soapbox cup. That's exactly what this is. Book Dragon KSC, tossing a coin to Runkle's soapbox. Thank you. The Miss Monty, thank you so much. Catherine Fallon, thank you for being a member. Or for becoming a member. But Rachel B. 315, off topic, Mormon Stories guy has done a live and an interview being sued. Would love to hear your opinion on if it's helping or hurting him. I have not dug into that one yet. I got to figure out and decide if I want to do it. I'm always a little careful with religious stuff just because they are. So, yeah. Emily Ahrens, ironically, Mr. Petty is not the pettiest party. Love it. Just Susie, I want to hear the Penn story. There's the Penn story. Scorpio, why do some lawyers take such bad cases? Seriously, I can show you why. I have a prop for this. The reason why is this. And you might be saying, Runkle, you're Canadian. Why do you have US currency in your wallet? Which is where I just pulled this out of. The reason why is because the last time I had to carry cash was when I was in the US. I don't usually carry Canadian cash. And then there's nowhere to spend it here in Canada. I mean, you can, but a lot of places will take it at par, and that's suck. So, Jill Marr for the Penn Jillette story. You've heard it. D Starfire, haven't seen a filing this entertaining since the Prenda Law saga. Oh, that takes me back. Just Because, thank you for being a member. Much appreciated. Vez from Quebec, happy Star Wars Day, folks. I forgot it was Star Wars Day for the Penn story. There we go. Not That Amber, thank you so much. Meg is autistic. Need to hear that story. Please give Zora and Potter pats for me later. Recently said goodbye to my cat, 15 and a half years old, so really missing paw snuggles. I'm sorry, Meg. And yeah, the pups. Potter has been really attention wanting lately. So I will, yeah. Law-abiding rebel. Yay, Runkle story time. Yes. Imagine trying to get a magician loaded with gimmicks through court security. I suspect they'd have to like bring them all in a box and then gimmick themselves up in the like in a bathroom or something. So yeah, it's what is it? Isn't that unethical for a lawyer to take a client's money in a civil case? And no, it's a loser case. I mean, you would tell people that that it's, you know, a long shot, and then they can decide if they want to blow their money. So yeah, it's unethical to take a frivolous case, but there can be a case that is shitty but not frivolous. Law-abiding rebel. Yay, Runkle story time. Thank you. Music to my soul. RIP to the Ask search engine, which closed on May 1st. Was Ask Jeeves the thing in Canada, Runkle? It was. I was kind of hoping Jeeves would make a comeback. Somebody's going to buy the IP, I'm sure. Mysterica Claus. Runkle Pigeon. Pigeon. Story. We've got the story. Thank you so much, Hollister. Thank you, Mrs. Kristen. Thank you, Slovak Girl. Thank you, Akasha4986. I grew up in the magic capital of the world. Oh, interesting. Ian BPK. Is that Vegas or somewhere else? Thank you for being a member. Kay Paris, Runkle, I hope you got your email. I just wanted to thank you for being the kind person. You were always the someone who's giving in kind. Thank you, Kay Paris. I think I got it. I'll have to check. Duani Madrid, thank you for the story. Thank you. Sandy136, please wish Harley a speedy recovery. He's been the vet hospital for pancreatitis. He's home now and doing better. I hope for a quick recovery because, yeah, that is a difficult thing. Yeah, hopefully all of that goes well. I always worry when my pup is sick. Imagine trying to work security with magicians. I feel like magic shows are probably pretty that. If you set another goal before I go to bed, I'll tell you. I think I have a goal going. Yes, I do. All right. So our next case here is an interesting one. At least I think it's an interesting one. The next case is about... Got to bring it up here. Oh, also, this next case has an interesting... it's interesting as well for who the other side is. So, anyone remember Brown Rudnick LLP? Is that a name that's familiar to you guys? Come on, somebody remembers where Brown Rudnick is from. Tell me that one. Depp's lawyers. Yep. They are on for the plaintiffs on this one. Now, this one is interesting. It is Rapid Relief Team, LIM Ltd, versus Cheryl Bottenheimer, the defendant. This one is bizarre to me. And this case hinges around this little bird thing. It's the RRT cookie bird. Now, but it's not really about the bird. What this is about is that Rapid Relief Team is a charity that is affiliated with a religious group that some people have alleged is a cult. And oh, don't forget the Rumble super chats. You're not wrong. I gotta look at Rumble. So some people have alleged that this is a cult, and they have criticized that quite a bit. And because of that criticism, there has been... Oh, and I see Drex's unused Baldo. Okay, there's the username. It says magicians are just bards who don't get laid. Love it. So what is it? Yeah, and I see somebody saying it's a cult. I escaped it. So basically the allegation is that Rapid Relief Team is... So the allegation is essentially that the Rapid Relief Team is a charity made to kind of whitewash the activities of the cult, or alleged cult, at least. So, and I forget I'm just blanking on the name of the group. It's the Plymouth Brethren Christian Church. So they do not like criticism, which means that they may not like my, that they may not like this. Oh, this is my case, unfortunately. Well, welcome aboard. Good to have you here. So what do they sue? Well, they bring an action seeking injunctive and monetary relief for defendants' intentional infringement of plaintiff's copyright in plaintiff's copyrighted stylized bird logo known as the RRT cookie bird. This is the cookie bird. And if you said that this bird looks like a piece of clip art, well, then you are already getting a preview of the defense side, because yeah. So what do they say? Founded in 2013 in Sydney, Australia by the Plymouth Brethren Christian Church, RRT is a global charitable relief organization offering compassionate support to communities impacted by national disasters and humanitarian crises. RRT's network extends through thousands of volunteers in at least 14 countries, including the United States. The copyrighted work was authored by Jose Gilberto Gonzalez do Porto and Rodrigo Clapano in 2019. That bird has 2 authors? I don't know how it takes 2 people to make that bird, but okay. So basically they're saying they got the rights to the bird. Okay. So they say that they use the bird on its merchandise, its promotional materials, and on its webpage. So this is a screenshot of their webpage, and that you can see the bird, right? The bird is there. So yeah. All right. So all of this is a copyright infringement claim officially, right? So jurisdiction and venue. Defendant expressly consented to jurisdiction of the federal district court for the district in which my address is located, or if my address is outside the United States, the judicial district in which YouTube is located, in the counter notifications that she submitted on December 7th and 14th and on January 30th, pursuant to the DMCA. Now, from what I understand, the defendant in this case is Canadian. Cheryl Bottenheimer is in Canada. And RRT is in Sydney, Australia. So between Sydney, Australia and Canada, they decided on the venue of California. Again, why? Why California? I am from Red Deer. Are you still in Red Deer? Because if you're still in Red Deer, I'm in Edmonton. So like we really close if that's the case. Like I could make a drive, and so yeah. So basically they're saying consented to the jurisdiction of California, which is bizarre. So like these two groups that are neither of them is in California are like, we are going to sue because YouTube is there. All right. So yeah, scrolling back here. Defendants infringing conduct. On information and belief, defendant is or was at the relevant time engaged in the creation or production of the Get a Life podcast channel on YouTube, which I totally missed that it was the... I was like, oh, right, we've got somebody with the username at Get a Life Podcast. And I did not... My brain did not put the two things together on that one. So, on information and belief, defendant is or was at the relevant time also engaged in the creation and production of the Rapid Relief Team Exposed channel on YouTube. On information and belief, defendant has, without plaintiff's authorization, consent, or knowledge, and without any compensation to plaintiff, reproduced the copyrighted work in multiple videos listed in whatever. And here's the thing. There is a non-trivial possibility that they will try to strike this video. And because, you know, in reviewing their court filings, they've got the bird in it. So, yeah, we'll see. So on October 28th, plaintiff's counsel submitted to YouTube a takedown request under the DMCA regarding defendants' unauthorized and infringing use of the copyrighted work in this video. After exchanging further communications with YouTube, YouTube removed the video. On December 14th, YouTube informed plaintiff's counsel the defendant had submitted a counter notification pursuant to the law. So, the video on the Get a Life podcast reproduces the copyrighted work, including, for example, as shown below. This looks like it's a screenshot of their fucking webpage. Like, that looks like what that is a screenshot of their webpage. So they're like, you can't include a screenshot of the webpage. Oh my God. So on January 28th, plaintiff's counsel submitted to YouTube a takedown request under the DMCA regarding defendants' unauthorized and infringing use of the copyrighted work in the video on the Get a Life podcast channel. The same video appears on the Rapid Relief Team Exposed channel available at, and reproduces the copyrighted work in the same manner. On January 30th, plaintiff's counsel submitted to YouTube a takedown request under the DMCA regarding defendants' unauthorized and infringing use of the copyrighted work in the video on the Rapid Relief Team Exposed channel. The video on the Get a Life podcast channel, entitled Rapid Relief Team, Where's the Compassion, with guest Damian Hasty, available... I don't know who Damian Hasty is, but I don't think it matters for this. Reproduces the copyrighted work, for example, as shown below. It's their webpage with some commentary posted on it. Like literally the webpage plus commentary. That's it. The same video appears on the Rapid... Okay, so more DMCAing. We're going to skip past some of the DMCAing things. There's more things about why are you showing our webpage. This is such bullshit, right? This is so weak. This is such garbage. And yeah, I don't see how this survives a fair use claim. They would have a better argument under fair dealing, but it would still be a shit argument. Like absolutely a shit argument. But instead, they're bringing this in California where they are going to, where they're going to get hammered. And when I say hammered, I mean in the sense of Dr. Horrible's sing-along blog, where you've got Captain Hammer going, these are not the hammer. Yeah. On information and belief, defendant's identical use and exploitation of the copyrighted work was willful and in disregard of and with indifference to the rights of the plaintiff. On further information and belief. So here's the thing. Information and belief is not when you wish upon a star. Right? Information and belief, you have to have a legitimate basis for. You can't just information and belief shit into existence that is not true. So, but here that appears like what they're doing. All right. On further information and belief, defendants' intentional infringing conduct was undertaken to reap the creative benefit and value associated with the copyrighted work. If anybody whatsoever wrote that shit down with a straight face, oh my God. Oh my God. I'm glad Camille Vasquez and what's his name? Oh, Ben Chu are not at Brown Rudnick anymore, because like, this shit is embarrassing to say that. Oh yeah, this is a gave expert testimony today. Never appreciated how little control witnesses have over what ground does or doesn't get covered. 100%. The lawyer is trying to be in control at all times. So by failing to obtain plaintiff's authorization to use the copyrighted work or to compensate plaintiff for the use, defendant has avoided payment of license fees. Nobody's going to fucking license your own webpage a screenshot when they're criticizing you. Or other financial costs associated with obtaining permission to exploit the copyrighted work, as well as the restrictions. I am going to say, without having seen the underlying videos, 0% of the value of those videos will be from showing a screenshot of that, right? Like, come on. As a result of defendant's actions described above, plaintiff has been directly damaged and is continuing to be damaged by the unauthorized reproduction and public display of the copyrighted work. Defendant has never accounted to or otherwise paid plaintiff for its use of the copyrighted work. Defendant's acts are causing, and unless restrained, will continue to cause damage and immediate irreparable harm to plaintiff, for which plaintiff has no adequate remedy at law. Yes, you fucking do. The remedy is cash. Right? The law presumes that anything that can be remedied with cash is not an irreparable harm. Right? An irreparable harm is like, this dude is going to cut my fucking leg off, and there is no amount of money that allows you to put a leg back on. But if it's just, I am going to lose $5,000 worth of loss, then there is no irreparable loss, because at the end of it, you just like pay the $5,000. That's what the courts are really good at. The courts presume that you can, the courts presume that that's what they do, right? That is, in fact, the kind of repair the courts are best at. So count one, federal copyright infringement. So they repeat and reallege all of the above. They say it's an original drawing, reproduction and public display, infringe. They say that it was willful and with full knowledge of the plaintiff's rights in the copyrighted work, and that the person is illegally profited from therein. They say, pursuant to the law, plaintiff is also entitled to recovery of defendant's profits attributable to defendant's infringing conduct alleged herein, including from any and all sales and other profits in connection with the infringing videos, and an accounting of and a constructive trust with respect to such profits. All right. So, and they also want a permanent injunctive relief restraining and enjoining defendants' ongoing infringing conduct. This is really what they want, right? Really what they're looking for is they want they want to prevent the person who is criticizing them from being able to criticize them easily. All right. So they ask for an injunction. All right. They want an accounting of the defendant's profits, that the defendant be ordered to destroy or deliver up for destruction all materials in defendant's possession, custody, or control used by defendant in connection with defendant's infringing conduct, i.e. all of the videos, And they say that they be ordered to recall the infringing videos. So take the videos down from anything that's there. Any profits from the videos they want. So they want all of the money. They want interest. Okay. So, Daniel A. Rosansky, Michael R. Grafe, and Catherine C. Deering all signed their name to this shit, which I think is a bold choice. Again, don't reach out. Don't contact anybody who's like, don't any of that stuff. But like, holy shit, that's a choice, right? I think it's a pretty embarrassing choice that they made. And, but they made that choice. They made that call. And, yeah. All right. So, let us look at the next filing. Because the next filing is from Randazza. And Randazza, he's spicy. He is spicy. So there's a couple of filings here. And all right. So here is the first one. All right. And yes, Anti-SLAPP may, yeah. They not only made that choice, but have doubled down. Oh, they have. And they are making some absolute choices here. So defendant and counterclaim plaintiff. Oh, maybe we should look at the counterclaim first. Yeah, here we go. Defendant and counterclaim plaintiffs answer and counterclaim. So, wait, I'm going to actually just check. This is document 26. Yeah, we're going to look at them in order of filing. So we'll look at document 26 first. I'm just going to bump that over. Here we go. All right. Counterclaim. Introduction. This lawsuit is a censorship campaign masquerading as a copyright case over a clip art cartoon bird logo. I love the shade there. Its true and transparent purpose is to try and shut down criticism of the Plymouth Brethren Christian Church. On its face, this looks like it. Oh, the counterclaim stuff is in the motions too. Okay, we'll skip that. We'll go to the motions. All right. Thank you. I appreciate that, because we are looking at the motion for preliminary injunction and memorandum in support. All right. Let's see. Yeah, we'll start here. The motion requests the court to decide the following issues. 1, whether Bottenheimer's YouTube videos using RRT's cartoon logo as part of criticism of RRT and its parent entity are fair uses. 2, whether counterclaim defendants issued DMCA notices in bad faith. There is a requirement for good faith. 3, whether Bottenheimer will suffer irreparable harm in the absence of an injunction. 4, whether the balance of hardship tips in Bottenheimer's favor. And 5, whether the public interest would be disturbed by the requested injunction. I love that the response here is an injunction request. It's like, all right, you guys want an injunction? We want an injunction first. Bottenheimer seeks an order from this court. 1, requiring defendants to withdraw all DMCA requests sent to YouTube regarding Bottenheimer's videos. 2, enjoining defendants from sending any more DMCA notices or other legal threats regarding these videos or any other clearly non-infringing videos. And 3, requiring counterclaim defendants to seek approval from this court to send any further DMCA notices regarding Bottenheimer's videos. Now, I'm just going to say here that if, and it's always an if, you never really, like, litigation doesn't have guarantees, but I think that they've got a pretty strong, pretty strong argument here. I think that this is actually, but if this is granted, Brown Rudnick should maybe look for their, like, Brown Rudnick pants, Because if the court grants an injunction that says, hey, you can't file any more, DMCA claims without our approval, then that would be a very strong indication that they are going to, that they're going to get hosed, essentially. So I think there's actually a pretty good case or pretty good chance that this goes through. So, introduction. RRT filed abusive takedown requests under the DMCA to suppress Cheryl Bottenheimer's First Amendment protected speech. Okay, let's talk about how the DMCA works. The DMCA is basically a provision for like rapid takedowns of stuff that's infringing. So let's imagine somebody copies this video in its entirety, in its like 2.5 hours, and and counting, and they post it up on their web page, right? And I want to take it down. Well, I can file a DMCA, and the host of that web page basically then has a choice. They can either take the stuff down, or they can sign on for liability. So if somebody posted this entire video, my entire video, to YouTube, I can send a DMCA, and that YouTube then gets to make the decision of, do we want to take this video down, or do we want the potential liability of getting sued over, YouTube doesn't want liability for like copyright infringement and so forth, right? That's not. So there are cases where where YouTube has refused a DMCA, but it doesn't happen often. But recognizing that process could be abused, there is a process for a counter notification. And the counter notification basically says, I am not infringing, put my stuff back up. At which point the material has to go back up. But the person who sent the notification basically has to make a decision. Do they want to sue, or do they want to just go, okay, fine, the DMCA count or notification process is done? If you sue, then you have, of course, all of the costs and litigation and whatever, which most people don't want to do. I've been in that process of being like, yeah, is Runkle the lawyer? No, I'm not the lawyer on this case. So Brown Rudnick is on the plaintiff's side. Randazza is on the defense side. So, yeah. All right. Those notices were signed under penalty of perjury by counterclaim defendants Katie J. Church and Michael Grave. So this is interesting because Michael Grave, you saw him before. He was one of the lawyers, right? So now he's kind of wrangling himself in here. I think as a lawyer, it's actually pretty bad practice. If you are like an IP lawyer or something else like that, I think it is generally bad practice to be the person signing the DMCAs. Because now you're signing stuff as the lawyer under penalty of perjury. And that's a whole fucking ball game. So I've covered a few cases now where lawyers who are IP lawyers have been doing their own DMCAs, and it can go badly. Like, it is not, I don't think it's a good idea. And yet I see lawyers do this all the time. I don't know why they do it. Like, have your clients sign the perjury letter. Why are you making yourself potentially on the hook there? All right. When the DMCA notices were issued, those who issued them had actual knowledge or willful blindness that their notices were in bad faith. And they note here Lens versus Universal Music, holding that willful blindness may be used to determine whether a copyright holder knowingly, materially misrepresented that it held a good faith belief the offending activity was not a fair use. That, by the way, might end up being a case that gets used in another case that we're not going to talk about. So, all right. Bottenheimer is a former member of the PBCC, also known as the Exclusive Brethren. RRT is ostensibly a charitable organization operated by the PBCC, but in reality does minimally impactful charitable work while being used to bolster PBCC's image. Bolstering is desirable because the PBCC has a history of abuse towards its members and those who leave it. Bottenheimer produces the Get a Life podcast, in which she and other former PBCC members criticize the acronyms and serve as a source of comfort and community for other former members who find themselves excommunicated and alone. Defendants' DMCA requests abuse the DMCA for the purpose of suppressing criticism. After filing its complaint, RRT continued to send frivolous DMCA requests, using the existence of this suit to try and legitimize them to keep Bottenheimer's critical videos suppressed. Factual background. While nominally a simple copyright case, there is significant relevant factual background. Actually, I don't know if Mark's still in the chat, but I have a bit of a sort of thing I'm pondering. And that is the crime fraud exception to there's a crime fraud exception to privilege. I'm spitballing here. This is not something I've thought about. It's not something I've done research in. But it's just kind of an initial, sometimes like novel, like new things come about through this kind of like ideas. So, if a client and their lawyer come together to generate a DMCA request for bad purposes, that would seem to be the client and the lawyer working together to generate a perjurious statement. And I can see an argument. I don't know if it'll pass. I don't know if it'll fly, but I can certainly see an argument. I can see an argument for saying that breaches privilege under the crime fraud exception, and that therefore all of those communications suddenly go in. I have to do research into this now. I have to look into it. This is one of those things where I'm just like, I might be full of shit, right? I might just be chasing my own legal tail here. And it might be that somebody's tried this and it's been rejected. It might be that there's some other problem I haven't seen. But, I mean, this could be... I'm going to have to think about that because, like, privilege between lawyer and client getting blown up is a really big fucking deal. And I don't know. I see. Let's just say you're not full of shit from our perspective. Okay. I want to see that argument. Oh man. That is tasty. Like, that is the kind of thing that like makes my lawyer brain like salivate, because I just go like, ooh man, that could be explosive, and could cause problems for some other people I know of. So yeah. All right. So the PBCC, also known as the Exclusive Brethren, is a wealthy cult with strong central control over its members' lives. It abuses any who seek to leave the cult. Despite its successful measures to lock down its members' personal lives, it has a shockingly high level of SA. I would say probably not despite. I would say that if you've got a cult, which is the allegation here, that locks down its members' personal lives, that is kind of an expected result. So Research presented in 2025 at the International Cultic Studies Association conference by Dr. Jill Aby-Mitten found that 41%, holy shit, 41% of former EB participants reported childhood SA, most often perpetrated within the organization. 41%? 41%? Like, if you get the plague, like the literal Black Death, more than 41% of people survive the literal plague. That's like, I'm laughing because it's fucking horrible. Like, that's insane. 41%? An organization that manages to keep its members from using the internet cannot apparently control them from essaying children. Oh my God. Members who leave the EB, whether voluntarily or through excommunication, do not just lose their religion. They are shunned and regarded as dead by spouses, parents, children, and friends. The cult's rules dictate that its members can only be employed by other members or cult-run businesses, so they frequently lose their jobs too. Wow, that is messed up. Given the fact that members are kept inside a sealed bubble, those who escape or are cast out are ill-equipped to deal with the outside world. The trauma from their time inside the PBCC, coupled with the removal of all support, leads to high levels of mental anguish and PTSD as they struggle to survive. LGBTQ plus people born into this community are treated as if their existence is an abhorrent sin, and some have been compelled to undergo chemical castration in an attempt to cure them. When this inevitably fails, they're cast out without mercy. So these sound like lovely people, and please, the sarcasm. Some of those who have left have spoken out. From the 1970s to the present day, a series of former members set up websites or spoke to journalists about the abuse they suffered. Each has been attacked with heavy-handed SLAPP tactics, intrusive surveillance, and abusive searches of their homes and electronics. All right, so I guess I got to worry about whether this is going to be a thing here. All right. While Bottenheimer was a child in the PBCC, she was essayed by an exclusive brethren PBCC elder. So that is from a declaration. After leaving the cult, she started the Get a Life podcast on YouTube with other former members. The podcast purpose is to show solidarity with other former members, to create a community to support those who leave, and to warn the public about the cult. Warning the public seems like a good thing, right? So it is devoted to revealing hypocrisy in the cult and sharing stories about members who suffered trauma at the PBCC's hands. Most of the episodes are interviews with former members exposing abuse and corruption in the EB. Some of these stories have been taken up by mainstream media. So various groups reporting on it, New Statesman. Oh, Canadaland gets a mention. Jesse Brown is a piece of crap, but I actually was coming around to him being okay, and then he was a further piece of crap. So, yeah. A number of documentaries and high-profile newspaper articles have been published that originate from the Get a Life podcast. So, various groups there. The PBCC's character came to the attention of the UK's charity regulator, and it concluded that the Preston Down Trust was harmful to society. So they canceled its tax-free charity privileges. This is not surprising, given that its leader advised people who left the cult to unalive themselves by ingesting rat poison or arsenic. Oh, wow. Okay. In order to regain a tax-exempt vehicle, the EB created the Rapid Relief Team, a public-facing charity whose operations are designed to gain maximum press coverage by setting up brightly branded red tents at disaster sites where conspicuously uniformed volunteers distribute supplies. The RRT functions as the PR wing of the PBCC in an attempt to counter and bury the darker truths. So, DMCA requests and Bottenheimer's videos. They claim ownership of a clip art bird. There's the bird. Except is that actually the bird? Oh, wait. Oh, that's from the podcast. Yep. The clip art bird here is not even the same logo, although it is similar, that appears in most of the videos that RRT took down. However, assuming arguendo that it was the same logo, or assuming arguendo that its derivatives are covered by the unregistered rights that RRT claims, the use in each and every video is obviously fair use. Not just obvious to the trained eye, obvious to anyone who's capable of conceptualizing fair use, even in the abstract, with no prior knowledge of Section 107 of the Copyright Act. Obvious to anyone. Yep. On or about October 28th, defendant church sent a DMCA takedown. So to the video titled Lindy expresses her concern regarding the Plymouth Brethren Christian Church's RRT charity. This request claims that the GAL video infringed the logo. The fair use is evident just by looking at the image the RRT put in its own First Amendment complaint, since even the title makes it clear that this is what it is: criticism and commentary about statements made on the RRT website. One of the things that the whole fair use is intended to deal with, that fair use exists for, is to prevent exactly this, right? Let's say that I go and, let's say that somebody makes a painting, right? And I want to say how much that painting sucks, because I think that painting really, really sucks. And so I do a thing where I pull up that painting and I look at it and I say, look at how much this painting sucks. Well, fair use is intended to protect exactly that. Fair use, so because otherwise it makes it impossible to criticize things, right? Somebody writes a book. I don't know. We'll just invent some random name for a book. Let's say somebody writes a book and we'll call it 50 Shades of Grey, just to make up a random fanciful name that nobody would ever name a book, right? And so let's say I want to say that the 50 Shades of Grey book sucks. The way I would do it would be to pull up snippets of the book and to comment on how and why they suck, right? Like, okay, look, here's this character, and this character sucks because of the following, right? Because otherwise, how would you criticize a book other than just generally saying it sucks, right? So this is the point of fair use. All right. It is rare that a plaintiff in a copyright case includes exhibits or illustrations that make it so plain to see the fair use. But here we are, as this and all the other images in this section are pulled right from the amended complaint. If we watch the videos, it becomes even clearer. But the court does not need to watch the videos, although it should for the sake of completeness. By the way, there is case law to the effect that when a video is in a pleading like that the court can watch it. So, yeah. That is absolutely potential there. Or to come to the conclusion that this could be nothing other than fair use. I mean, the court might actually want to watch this and be like, oh my God. Obviously, the video at issue in the first DMCA request criticizes RRT and notes its connection to the EB/PBCC. The video specifically discusses how people find RRT's branding and promotional material to be disturbing. The complained of image in this video is a display of RRT's website, including the text "Compassion in Action, Supporting Communities in Need." The image appears for 15 seconds out of the 5-minute video. All right, that's not a long time. This video discusses how this text is ironic coming from RRT, given that they are in no way compassionate, nor do they support communities in need. Of note is that the video does not feature Bottenheimer at all. Rather, it exclusively features a third party discussing RRT and the church. On or about October 28th, the counterclaim defendant church sent an equally abusive DMCA takedown request targeting the GAL video, posted Rapid Relief Team, Hypocrisy, and Families Divided at Christmas. This request claims that the GAL video infringed the logo by displaying the following image. And so that's the image. Again, one needs to go no further than the title, Hypocrisy and Families Divided at Christmas, to see how this is a fair use. The video at issue in the second DMCA request criticizes RRT and how the PBCC divides families at Christmas, while their website says that they're bringing members together for the holiday season. The complained of image in this video displays RRT's promotional message, bringing families together for the holiday season, which appears for 17 seconds. Okay. Oh, yeah. And they say the image appears for 17 seconds. I didn't have to do the math of the 3.5-minute video. This video discusses how this promotional material is hypocritical to people familiar with RRT and the exclusive brethren / PBCC, as the cult actively works to separate families if any of them dissent from the cult's teachings. So Bottenheimer sent DMCA counter notices. That's how they get jurisdiction, is through the counter notices, because the counter notices require you to consent to the jurisdiction in California. So counterclaim defendants were not done, though. They sent another DMCA takedown request, once again requesting removal of the same videos. Purpose of the request was to exploit YouTube's policies, which state that YouTube may re-remove a video that is subject to pending litigation. Right. So the lawsuit gets them to take stuff down. Okay. When the abusive practices did not seem to do the job, they rolled out the big guns. Counterclaim defendant Michael Grafe targeted the video posted on YouTube, Get a Life 144 Rapid Release Team Branded Trauma. Ex-members speak out. He claimed that the video violated the logo by displaying the same image. So once again, all right. Skipping ahead a little bit more here. More takedowns, lots of takedowns. The allegedly infringing image is no more than a screenshot of their own website displaying the RRT logo with the text, Compassion in Action, supporting communities in need. All right, so counter defendants Church, Grafe, and Brown Rudnick, at the behest and / or specific instruction of RRT, sent the above DMCA requests for the purpose of censoring Bottenheimer's criticism and not to redress copyright infringement. And this is not a one-off newfound desire to abuse the courts to censor critics. This is PBCC's modus operandi. In 2009, the PBCC filed a SLAPP, including a claim of copyright infringement against the operator of a website that offered an online sanctuary for people to escape the cult. So the same publishing arm filed suit. You know what I should have done? I'm now kind of pissed off at myself for not thinking about this. So in the chat, I have the pigeon emoji. I also have pigeon merch. I need to hire somebody to make the pigeon, make a pigeon that is dressed in like a high-vis vest and a blue hat. Because this is some pigeon business. So, all right. In 2009, they filed a SLAPP, including a claim of copyright infringement against the operator of a website that offered an online sanctuary for people to escape the cult. The same publishing arm filed suit for defamation and copyright infringement years earlier in Minnesota against the operator of a different criticism website. That case eventually resulted in a settlement, which required the operator to transfer his criticism websites to the exclusive brethren and agree never again to publish about the cult. Yeah. They sued major Australian media outlets and journalist Michael Bachelard for defamation following investigative articles alleging institutional cover-ups of child sexual abuse within the church. The defendants successfully dismissed the lawsuit, which dismissal was upheld on appeal. Around the same time, the PBCC's publishing arm sued a retired Scottish academic for copyright infringement after he published short extracts and quotes from the cult's internal sermons and teachings as part of criticism about the cult. So, and in 2020 in New Zealand, a company closely linked to the PBCC obtained a civil search and seizure order that led to a pre-dawn raid on an ex-PBCC's member's home, seeking seizure of electronic devices and documents after the ex-member publicly criticized the cult. How the fuck did they get that? Is New Zealand just really, really like toxic? Like, does New Zealand allow? Because in Canada, that would be called an Anton Pillar order, and it's really hard to get. So, in this latest round of stifled criticism, the censorship has been successful so far because counter-defendants successfully gamed the system. In response to each of the above DMCA requests, YouTube disabled access to each of the critical videos. Removal of these videos caused Bottenheimer monetary harm. While the monetization was minimal in the tens of dollars, she still suffered economic loss. But the few dollars she might have earned are not the irreparable harm here. Money is repairable harm, right? The irreparable harm is going to be the First Amendment. So the irreparable harm is the inability to spread public awareness of RRTs and its activities. Freedom of speech, freedom of expression. Right now, there are potential escapees from PBCC or those who have been cast out who have once again lost the ability to find help, just like when PBCC destroyed such online communities in the past. The interesting thing there is that by filing this, they're now putting a lot of this stuff. They're now putting a lot of this stuff potentially into the public record. So now a lot of this stuff can be litigated. So, if Bottenheimer were to re-upload them, it is clear that RRT and its counsel would simply issue another copyright strike since they've done so even during the pendency of this litigation. YouTube would not reinstate the videos due to the existence of the lawsuit. Due to RRTs, so watch this video now, share this video now with your friends because there's a really good chance that this video gets taken down. It's non-trivial, at least. Due to RRT's tactics of censorship, as shown by its history, this lawsuit, and the numerous bad faith DMCA takedown requests, Bottenheimer also fears that any future videos regarding RRT will be subjected to more bad faith censorship. Too many copyright strikes on our YouTube channel will result in the channel being disabled entirely, which would be devastating on our ability to report on RRT and the PBCC. So, legal standard. A preliminary injunction should enter if a plaintiff establishes 1, a likelihood of success on the merits, 2, irreparable harm, 3, equities in her favor, and 4, no disservice to the public interest. So, courts regularly order retraction of takedown notices as preliminary relief. That I didn't know. There's a bunch of cases that that cite that. Or Amaretto Ranch Breedables, LLC versus Ozimals. I don't know what that is, but I don't want to know. So, but there's various cases that have granted the preliminary injunction. Let's see. And we have a goal. It is at 0. I am a bad grifter. It is what it is. I gotta like, ask some of these other YouTubers how they grift, because I am not excellent at it. All right. Bottenheimer is entitled to a preliminary injunction ordering RRT to withdraw its requests. So, all right. Bottenheimer has a likelihood of success on her claims. Quite frankly, I think that is really obvious. Super obvious. This is so obviously fair use. And what I mean by this is so obviously fair use is that I have covered past cases, including cases where the court was so pissed off about the where a tribunal was so pissed off about just how abusive the claim was that that they were like actively mocking the claimant. And this is more obvious than that. So I don't see like how you can try to I don't see how you can claim to be a to be like a copyright lawyer without looking at this and going, yeah. All right, so RRT started this fight because it doesn't want to be criticized, and this is a harm that the Copyright Act is not here to address. A weak copyright claim cannot justify censorship in the guise of authorship. That is an excellent quote. So, the fair use of a copyrighted work for purposes such as criticism, comment, or news reporting is not infringement of copyright. Also fairly obvious. So factor one, the purpose and character of the use. Now we're going to get through the 4 factors, right? The four copyright factors here, right? So, Tinfoil Hat Society says, just say send money. Fair. What is a goal? Well, a goal is something YouTube set up to, but I'm just opening the cider anyway. All right. So the first fair use factor requires an analysis of the specific use of a copyrighted work that is alleged to be an infringement. The central question it asks is whether the new work merely supersedes the objects of the original creation, supplanting the original, or instead adds something new, whether a further purpose or a different character. So a use that has a different purpose or character from the original is said to be transformative, and the more transformative a use is, the less significant the other factors will be. So as an example of the, as an example of like transformative use, right? Well, mockery is kind of one of the characteristic things, right? So, if you've got a company that sells like a shirt that says, that has their logo on it, right? And you make a logo that's very similar, but is obviously making fun of that first thing, then you're into fair use, right? Or you're likely into fair use, right? It's a different purpose. And so the question is the purpose of RRT's logo the same as the purpose of the video that is criticizing the RRT? Obviously it's not, right? When a logo identifies a company, it is per se fair use, or fair to use that logo nominatively to identify the company, especially when criticizing it. Can you imagine if you are sitting there and you do, you've got the McDonald's arches and you say sucks. Well, you're not using the McDonald's arches in the same way McDonald's is. You're using it to indicate that McDonald's sucks, right? So, yeah. The uses were not even of just the logo, although that would not change the analysis, but specifically the logo as it appeared on RRT's website, containing promotional material published by RRT, where the commentators were criticizing the organization based on that very promotional material. The court should review the videos in their entirety, but even the screen captures that RRT itself selected show that this is criticism and commentary, and thus a fair use. In a case that is directly applicable, the Fourth Circuit Court found that it was transformative to use the Baltimore Ravens logo to identify the team while discussing the team in a historical context. So, all right. Bottenheimer's use is identically transformative. She did not use the logo for its artistry. What artistry? The logo sucks. The logo is kind of shit. She was using it to identify RRT in a video criticizing RRT in the statements they published. Yeah. I think that is, I think this one's a fairly obvious thing. If one were trying to make a bad faith, desperate argument, one might argue that Bottenheimer's videos criticize RRT itself rather than the RRT logo specifically, and thus her use is not transformative. I'm guessing the other side is going to make exactly that argument. That is the only remotely hypothetical argument that can be imagined here, but courts have repeatedly found that using a copyrighted photo of a person when criticizing that person, rather than critiquing the photo itself, is a fair use. See Dillon versus Doe. That's going to be a useful case. I'm going to remember that one. So, use of a plaintiff's copyrighted headshot for an article criticizing plaintiff's view was paradigmatic fair use and was transformative because it served the purpose of criticism rather than identification. So, using plaintiff's copyrighted photo on website and social media accounts to criticize plaintiff by identifying plaintiff's bankruptcies and claiming that he loves ripping old men off was transformative because they were used for negative criticism and not identification and positive development of Edelat's internet presence. So I'm just like putting a little bookmark here on this because all of this is very useful for things that might happen in future. Factor 2, the nature of the copyrighted work. The nature of the work favors fair use. The plaintiff admits the logo was created to identify the organization. This makes it more of a functional work than a creative work. So, yeah, what are they, differentiating between functional and, functional and creative? Well, like the McDonald's arches are functional, right? They're very simple. There's not a whole lot of artistry to them. What is the purpose of the McDonald's arches? It's to make you want to go get a burger, right? And to make you aware that the burgers in that place will be the same shitty ass burgers that you find in any other place that has the same arches, right? That's the purpose of it. Whereas like a creative work is something like this thing, and I mean, sure, it's just a picture, but it's a picture that like required some framing, some, so that is, yeah. To make my kids say burger fries over and over, fair enough. So courts have found that images used to identify a person or entity are more informational than creative. All right. Factor 3, amount and substantiality. Under the third factor, while Bottenheimer used the entirety of the logo or a derivative of it, that doesn't tilt this factor in RRT's favor. Use of an entire work can still be fair. For example, if I wanted to take this image behind me and I wanted to criticize it, I wanted to say it's awesome or that it sucks, whichever, it's hard to do without the entire image, right? A painting is hard to criticize without using the entire painting. A book might be criticized by snippets, right? But a video might be that you have to criticize the entire video, or it might be that you want to look at certain portions of it, like different bits. So, though the NFL has used Bouchat's work in its entirety, the transformativeness of the use and the character of Bouchat's work lead us to give very little weight to this factor. It would be senseless to permit the NFL to use the Flying Bee logo for factual historical purposes, but permit it to show only a half or 2/3 of it. That makes sense, right? One must, by necessity, use the entire RRT logo to criticize RRT. If that were not the case, all a company would need to do in order to ensure that it cannot be criticized would be to use its logo on everything it produces. If one cannot use an entire logo to criticize an organization, then no newspaper could criticize the Republicans or the Democrats by using their elephant or donkey. Protesters who dislike Elon Musk won't be able to hold signs with the Tesla logo on them without paying Elon a royalty. Donald Trump himself has a designed coat of arms. Wait, he's got a coat of arms? Weird. Okay. If the RRT's theory is a shred of power, this factor is neutral. You might be saying, why is Randazza mentioning Donald Trump here? We're not going to get too political, although I think Randazza's, I think he's a Republican voter. I'm not sure. The reason why this is mentioned is that fundamentally the fair use things tie into the First Amendment, right? Freedom of speech. And the most fundamental element of freedom of speech, the most basic fundamental thing is fuck your hat. And I'm going to embiggen myself for this. What I mean by the fuck your hat is the William Tell story. William Tell is the story of some local ruler goes and puts his hat up on the up on a post, and he demands that everybody who walks by salute the hat, right? Or bow to the hat, depends on which version you're reading, right? But you got to show respect to this guy's hat that is up on this post. And William Tell walks past the hat and does not salute and does not bow. But they actually have a like guards posted, and the guards go, "You, why didn't you salute the hat?" And he goes, "Well, because fuck your hat. Fuck your hat," right? And so they arrest him, and they do all the stuff, right? And in the end, William Tell murders a bunch of people, which was, well, not murders, justifiably kills a bunch of people, and lives happily ever after, because William Tell is a badass in this story. He's like, he's like medieval John Wick. So, but the idea is that when you've got like a king or a president or whatever, that the First Amendment's most basic atom is for you to see that guy having his parade or whatever else and go, fuck y'all. That is the fundamental basics of what the First Amendment is there to protect. See that guy who thinks he's important? Fuck him. And so, like, it is critical that this exist in a way that allows you to say, fuck that guy, including to Donald Trump, Elon Musk, etc. So without getting political, because the same is true when it's Obama or Biden or, whoever gets elected next for the Democrats at some point in the future. That's the fundamentals. And I mean, it goes a little, further on, but yes. All right. So they say this factor is neutral. I don't know if I agree with Randazza on the amount and substantiality. I might actually, well, I suppose neutral is the best you can get when it uses the whole thing. Fair enough. I still kind of feel like it leans in the favor of the, because they didn't use the entire web page, for instance, just the logo. Effect on the market for the original. So what the effect on the market for the original is will people watch your version instead of the other, like the original version? So if you think to Ethan Klein's lawsuit, his argument was that they were specifically saying, I will, we will vote for this instead of, or we will watch this on this channel instead of this other channel, right? I'm going to set another goal. It's going to be just a fun. Oh, wait, this one's still going on. Let's say I make I've got the pigeon business shirt. If you copy the pigeon and make your own shirts, well, then the purpose is that every person who's buying a shirt from those other people is not buying a shirt from me. And they could be buying a shirt from me, right? So, like, that's the thing. But people criticize sometimes. I remember there was some, I was covering some, what do you call it? Some video that was posted to YouTube. And the video that was posted to YouTube was like a 30-second video of a crime. And somebody was like criticizing this going, oh, you managed to turn a 30-second video into like, a 20-minute discussion. I'm like, they're like, just play the video through. I'm like, no, go watch the original. I link the original. Go watch the original. I am discussing it because of, to show you the things. And I did get a red super chat, I just see, so. Salagamin says, hello from halfway around the world. Hello. So, hello. So, yeah, it's, that's kind of an important thing, right? If I do a video that says like, look, I have a video where I talk about one episode of Better Call Saul, and I use like a minute or 2 minutes of that episode of Better Call Saul, right? If you watch my legal criticism of that Better Call Saul moment, you're not going to go and say, okay, I'm going to, I'm going to stop. Like, I'm not going to watch Better Call Saul because I saw it on Runkle, right? Instead, you're going to be like, if anything, you might be like, oh, I want to see the whole episode now, right? But it's not going to satisfy your desire to see the original. So, indeed, Runkle, that is a good reminder that fair use on video reproduction, one of the prongs is use as little as needed to make the commentary or criticism. Yes, with some asterisks on it, but yeah. All right, we asked not whether the second work would damage the market for the first, for example, by devaluing it through parody or criticism, but whether it usurps the market for the first by offering a competing substitute. This is an important difference as well. Let's say there's a movie out, let's call it like they make another Star Wars, right? And in this new Star Wars movie, Luke comes back to life because no reason. And the movie is really about like, the whole movie is about Chewbacca finding love. It's a romance between like Chewbacca and a toaster oven. And it's got like a 45-minute sex scene of Chewbacca fucking the toaster oven. So, I watched that video or that movie and I go like, holy fuck, this is awful. Having seen and so I then go and clip that, and make a video saying that, this movie is awful. And like, I show you snippets of the movie. And everybody watches my videos saying how much this, like the Star Wars movie sucks, like the new Star Wars. And nobody who sees my video goes to watch Star Wars. They're all like, oh my God. And that is diminishing the market for the actual video, but it's doing so by pointing out that the actual thing sucks. It's not by... it's not by people going, oh, I'll watch this because it does the same thing. So the effect on the market for the original is zero. I agree with that entirely. Bottenheimer's use might harm RRT by the force of its criticism rather than by supplying the demands of the market, but that does not create a copy or cognizable harm under the Copyright Act. I 100% agree. Nobody is going to watch Bottenheimer's video just to be like, okay, we're gonna see this. And like, it's a corporate fucking logo. Nobody buys a corporate logo in order to just like, ooh, I really want to see that corporate logo. Right? Nobody is buying it just to sit there and be like, ooh, I'm admiring this, like, this bird clip art, or like, at the furthest end, nobody's buying it to be like, hey, I'm gonna like, I was gonna say something crass. Like, just nobody's doing that, right? I've started a new goal. The new goal is to eat a chili pepper. I went and bought some chili peppers. I don't know why I bought so many. Oh wait, because it was $4.38. That's why. I bought chili peppers. So they are Thai chilies, bird's eye chilies. Yeah, if you hit the goal, we'll eat one. So RRT admits the logo is a source identifier for RRT. This is more akin to a trademark issue than a copyright. But even if it had been pled as one, it would be subject to the doctrine of nominative fair use. And using the DMCA for trademark claims is bad faith, so Bottenheimer still wins. Love that. The market harm that RRT asserts is just complaining that it doesn't like criticism, a harm that the Copyright Act cannot and was never intended to remedy. A weak copyright claim cannot justify censorship in the guise of authorship. If I have a criticism, I think he's used this same quote 3 times now. So, all right. Counterclaim defendants clearly violated 17 USC 512. So a claim for violation of that has 3 elements. 1, the defendant knowingly and materially misrepresented that copyright infringement occurred. 2, a service provider removed or disabled access to the material claimed to be infringing. And 3, that the plaintiff has been injured as a result. So, pursuant to the law of the DMCA, a copyright owner may be held liable for damages caused by an erroneous invocation of the notice and takedown provision only if the owner did not possess a subjective good faith belief that its copyright was being infringed. So liability for money damages and attorney's fees under this section extends to any person who knowingly, materially misrepresents under this section that material activity is infringing. And the thing is because liability can flow from this, signing this themselves, the lawyers signing this, is in my view a mistake, because it actually creates the possibility that that now the lawyer could be liable, and not just liable, but also a defendant on the claim. I like the opening scene of Ray scavenging a derelict. It implied something awesome was coming. No, you thought it implied something awesome was coming. What it actually implied, or what it actually was a metaphor for those movies. Because what it was is Ray symbolizes Disney. And scavenging a derelict symbolizes mining the Star Wars franchise for like any hope of, or any little fragments of nostalgia. And so that's what that scene symbolizes. It's we're gonna strip this franchise for parts, is really what that comes down to. I have some feelings about the Star Wars movies, or at least the most recent ones. Those feelings are, they sucked. But yeah. All right. They note, while this is a high bar, it is hardly unattainable, even at the preliminary injunction stage. So attorneys should be charged with some degree of constructive knowledge of fair use, even if lay people deserve more latitude. So counter defendants Brown and Rudnick, Church and Grafe could not possibly have been unaware that their DMCA requests were bad faith. Brown and Rudnick served as plaintiff's counsel in a case brought under 17 USC 512F just over a year ago. In that case, they represented a party that was victim to ill-considered DMCA takedown notices who filed suit against the alleged copyright owner. This is why I say don't fuck with Randazza, because he will research the fuck out of you. And like, he's like, hey, I know where you live. That's what this is. However, at least the party who sent the DMCA takedowns was trying to protect their monopoly on certain footage and not trying to censor a critic. The takedowns were a bad idea and failed to consider fair use, but at least they were not knowingly abusive like in this case. Here, Brown and Rudnick's attorneys certainly had access to that knowledge. But even without that case in their firm servers, these particular lawyers tout themselves as experts in the field. So see Brown and Rudnick profile for Michael Grafe attached as Exhibit 2. Oh my God, we are using the other firm's like website now. This is glorious. Advertising Grafe as having decades of experience in intellectual property practice with a focus on various practice areas, including copyright enforcement and fair use. Actual knowledge of copyright law and fair use should have merged with good ethics and resulted in them telling RRT no. Instead, they used that knowledge to try and game the system. This is Randazza going, all of you think I'm locked in here with you. But I'm not locked in here with you. You're locked in here with me. He just pulled the Rorschach. So yeah, that So there's no plausible excuse for a sophisticated plaintiff like our RTT, whose various affiliated entities have been suing critics for copyright infringement for decades, not to be aware that Bottenheimer's use of the RTT logo in her videos was a fair use. And credit to the logo, of course, goes to RTT here. There's equally no possibility its attorneys who sent the DMCA request were not aware that Bottenheimer's uses were fair uses. Any reasonable person, and certainly any reasonably competent attorney, it's always a good place where you can force the other side to plead incompetence. Like, oh yeah, we weren't engaged in like willful bad acts. We are just incompetent. Put that in a filing, motherfuckers. Oh, love it. Accordingly, counterclaim defendants cannot avoid liability merely because they pay lip service to consideration of fair use by claiming that they formed a good faith belief when there's evidence to the contrary. Even if that evidence is circumstantial, the overwhelming circumstantial evidence here is inescapable. The only plausible explanation is that counterclaim defendants chose to falsely represent that they had a good faith belief her uses were not authorized by the law. The obvious motivation was to silence a critic of their wealthy client. In response to the request, YouTube removed several of Bottenheimer's videos. So Bottenheimer suffered damages both in terms of lost income and her inability to carry on her work of informing the public about RRT and the PPCC. So thus issued bad faith DMCA takedown requests, and she will succeed on this claim. Irreparable harm, we're going to skip over a bit because this is long, but basically the irreparable harm is I can't speak. They are silencing me, and I cannot get my speech back. Remaining, you can't like repay me my speech. Remaining preliminary injunction factors favor Bottenheimer, so she'll suffer irreparable harm. They will not suffer irreparable harm. Yeah. Court should require at most a nominal bond. So a bond is like you pay money into court for the injunction that essentially you can lose if you lose later on, just to cover their losses. And so the court may dispense with a bond when there's no realistic likelihood of harm to the defendant from an injunction. I think that is the case here. The bond is basically to cover the possible losses. Now you might be saying, okay, surely they read that and went, all right, we are going to back away from this. We are going to take our losses. And nope. That is not what they do. Instead, they are coming in hot and saying that they are going to fight this to the utmost. So here we go. Because this is Brown and Rudnick's response to the motion. All right. They say defendant and counterclaim plaintiff Cheryl Bottenheimer's counterclaim is not merely deficient, it is an improper attempt to weaponize the DMCA. I'm sorry, what? Pot Kettle? What? The fact that somebody at Brown Rudnick was able to like write this down without going, wait a minute, is unfathomable to me. We have a goal. Apparently nobody wants to see me eat a spicy thing. We will just cancel the goal then. Goal fail. There we go. This, I mean, this is some balls. This is like the absolute balls on these lawyers is holy shit. By converting a routine good faith dispute over fair use into a claim for damages not only against RRT, but against RRT's attorneys in this case. You signed the papers. So the courts have recognized the particularly nasty type of scorched earth tactics associated with a calculated effort to undermine the parties in the underlying case by turning their attorneys into fellow defendants. Then why'd you sign the fucking papers, dudes? And I'm sorry, I don't have a whole lot of sympathy for the Brown Rudnick lawyers here. I turned the goal off. I can put another goal here. All right, people are saying I should put the goal back. I'm putting the goal back. Here we go. No, you poo-pooed my Star Wars. I don't like coconut. The drink idea is fine. I don't like coconut. So I'm not going to support yours. Fair. Coconut bad. And I see Drex's unused Baldo saying, speaking of Johnny Depp, did you hear he released his own rum? I heard he released his own rum. I haven't actually tried it. What is it? I ordered a bottle and it'll be here this week. We'll let you know how it is. Surprisingly, only like $80 a bottle. I wouldn't mind trying it. So yeah. All right. The statute imposes liability only in the narrow circumstance where a copyright holder knowingly makes a material misrepresentation of infringement. It does not punish enforcement efforts grounded in a genuine belief of infringement, nor does it transform a disagreement over fair use into actionable misconduct. Yet that is precisely what Bottenheimer seems to do here. There's something particularly striking about this counterclaim. The underlying facts are not in dispute. RRT owns a valid copyright in its logo. Bottenheimer used the logo in her videos, and she did so without authorization. Bottenheimer does not and cannot plead otherwise. Okay. Her sole potential defense is fair use, a doctrine that presents a mixed question of law and fact, and one on which Bottenheimer bears the burden of proof. But it's one on which the burden of proof is fucking obvious, dudes. Like, this is obvious. So obvious. At most, this case presents a contested legal issue regarding fair use. It does not present and cannot be recast as a case of knowing misrepresentation under 512F. I mean, it'll be real interesting if, privilege gets blown open, because that could be interesting. Unable to plead facts showing subjective bad faith, Bottenheimer, here's the problem with subjective bad faith, is that it's hard to get to subjective bad faith because we haven't yet invented mind reading equipment. But Bottenheimer instead resorts to conjecture, conclusory assertions, and rhetoric, claiming that counterclaim defendants must have known her use was fair and therefore must have acted improperly in submitting takedown notices. Here's the thing, though. If this survives a motion to dismiss this counterclaim, then y'all got to be worried because y'all getting deposed at that point. So, claiming that counterclaim defendants must have known her use was fair and therefore must have acted improperly in submitting takedown notices. But Ninth Circuit law forecloses that theory. Claim under 512F turns on subjective good faith, not on whether an opposing party or even a court might ultimately disagree about fair use. Even an unreasonable mistake is insufficient. Liability requires actual knowledge of falsity, where, as here, the dispute reduces to a disagreement over fair use. Courts routinely dismiss 512 claims at the pleading stage. And it might be dismissed, but I think it's real interesting. And the thing is go ahead and plead that it's an unreasonable mistake. Like, say it's an unreasonable mistake. The counterclaim is especially untenable given the circumstances under which the takedown notices were submitted. Those notices were sent by experienced counsel who should know better, as Bottenheimer herself acknowledges, who considered the possibility of fair use and in the exercise of professional judgment concluded that Bottenheimer's use was not authorized. Oh, I want to see that analysis. Show me your fucking analysis. Let's see it. That is precisely the type of good faith enforcement activity the DMCA is designed to protect, not penalize. Attempting to recast that judgment as a knowing misrepresentation did not make it so. Okay. So, factual background. Cookie the Kookaburra is a professionally designed, stylized cartoon bird character that RRT is used as a logo on its equipment designed to support emergency responders in communities in need, including but not limited to semi-trailers used to transport all-terrain forklifts. Yeah. You're going to talk about how awesome you are. Cool. All right. So they say they found the images. All right. Legal standard. Claim under it. Good faith belief on the takedown notice. Okay, I want to see general pleading requirements. All right. Well pleaded. Yep. They say it fails to allege a plausible claim. Where is your... I want to see their analysis on the fair dealing or fair use. Do they get one? Unsupported conjecture, conclusory statements are not entitled to an assumption of truth. Okay, so they're getting to pleading arguments. I'm not skimming past this because I think their arguments are bad. They may well win. I just want to see if they actually have anything. Here we go. They're getting to fair use. Regarding the fair use allegations, the court should not accept as true Bottenheimer's allegations about whether copying of RRT's logo was or should have been considered to be fair use. The tenet that a court must accept as true all of the allegations contained in a complaint is inapplicable to legal conclusions. While fair use is a mixed question of fact and law, the ultimate question of whether the facts amount to a fair use is a legal question. So, once these conclusory allegations are disregarded, as they must be, counterclaim count one consists of nothing more than a disagreement over fair use. Okay, but where are your actual... okay, so they're saying subjective versus objective standard. Okay, fair enough. Where is the actual... Like, are you going to put in a fair use? I bet they don't put in a fair use analysis here. Subjective standard applies in the context of fair use. In that regard, the Ninth Circuit held in Lens that although a copyright holder is required to consider fair use, if a copyright holder forms a subjective good faith belief that the allegedly infringing material does not constitute fair use, we are in no position to dispute the copyright holder's belief, even if we would have reached the opposite conclusion. But what if their conclusion is dumb? What if their conclusion is ridiculous? Right? What if the conclusion is insane? Like, how stupid does the conclusion have to be before the court can step in? That's going to be the question here. Dismissal should be without prejudice or with prejudice and without leave. Oh my God, they don't even get to a fair use. So they're like, look, we considered fair use. And they did not at all actually assert, like, they didn't run through the test. And so if you're saying you have a good faith belief in your fair use analysis, why not show us the fair use? Why not show us how you get the good faith belief, right? Show us how, show your work. How did you get to a good faith belief, right? How do you get there? Show me. Show me something. All right. Let's cover some super chats here. Tinfoil Hat Society says, just say send money. Fair. TX Forever, is there a cash cap on goals? Couldn't change it. Could very well be an ID10T error. I don't know if there is. So I might be pronouncing that wrong, says cheers. Cheers. I'm wrangling with this. Runkle, don't forget your Rumble super chats. I think I've read them all. Colon, Michigan. Are you kidding me? There's a town called Colon? Okay. That's not good. And this is the magic capital of the world. The magic capital of the world is Colon, Michigan. The place where people go to make things disappear. Yeah. All right. Harry Blackstone is buried there. I am not going to be asked to be buried in Colon. That does not seem like a great place. All those Rumble ones are for me as a heads up. Oh, you tough cookie. Thank you for the 10 gifted memberships. Much appreciated. Soul Kyle Mama, drinks are good, but stories are better. The promise of a fun Runkle story motivates me to super chat. Old cases, bizarre things you've seen, etc. I've got to figure out good stories to tell. Meme Empress, does a coat made of arms count as a coat of arms? If I ask where you got all the arms from, yours get added. Or if you ask where I got all the arms from, yours get added to it. Well, that is creepy. So, yeah. Let's see what happened here. Okay, I'll figure that out later. They brought Chewbacca back from the dead too. In that case, LMAO. Fair. Fair. So, yeah. Okay, that's not working. All right. Yeah. I have a thing that I was trying to fix, and it is not fixing, and it is making me sad, but I will have to solve that later. Wait, Chewbacca died? When did Chewbacca die? Oh, well. Get peppered. Fair, we will try. Professor of Logic, thank you. Welcome aboard. Salegamine, thank you. Welcome. Thank you so much. Michigan Farm Boy, but RRT has to do a good faith analysis that it isn't fair use before filing the DMCA, right? Yes. So let's see their analysis. They don't want to show their analysis. Honk Banana, no. Thank you for the 10 gifted membership. Much appreciated. B is for Bob. Thank you for being a member. I would just say, like, I think that it would be much... I think that it would be much stronger if they say, look, we can do a good faith analysis. Here is what the good faith analysis looks like. And, you know, you might come to a different conclusion, but at the end of the day, it's a, you know, it's still a good faith analysis, right? But yeah. All right. Do we want one more thing? A short thing? Yes, no. I don't know. Yes. Okay. I'm seeing some yeses. All right. Let's cover one more thing. And this is a recent development out of Canada that I previously covered a little bit. We're going to have a look at it. So here we go. This is a story out of the Toronto Star. So go check out the Toronto Star. We're not going to go through everything in it, but the judge slams veteran prosecutor for angrily telling Toronto cop, "We protect our own." Dangerous driving case tossed. All right. So I'm hoping there's going to be a written decision. I couldn't find a written decision yet. Yeah, I'll bite, eat a pepper. By the way, did you see that Blake and Wayfarer settled? Yes, the thing. I did see that they settled, and I'm very curious about the terms of that settlement, but we'll never find out. So, what happened in this case? Well, in this case, the allegation that was made by defense counsel was that a police officer offered some testimony that was harmful to the prosecution's case. And so the allegation then was that the Crown prosecutor, Marnie Goldenberg, who is seen in this still is from a surveillance camera, and she was seen angrily confronting that officer outside in the hallways. Now, those cameras do not record audio, so they didn't have the audio, but the officer was able to testify as to the substance of what happened. And he took some notes, and those notes included that he asked her whether he was supposed, like, apparently she confronted him and was pissed off about his testimony, which harmed the case. And she was like, basically, don't do that again. And so he apparently asked if he was supposed to lie on the stand. And her response, according to his testimony, was, "We protect our own." So the court found that this was that this is something that happened, and you can see there she is, like, confronting that, and so forth. And so the judge in the case found that this behavior, this sort of, she found that the prosecutor was less than candid in her testimony and did not provide the court with a fair and fulsome account of what took place, and displayed a complete lack of objectivity about the case. The thing says, by telling Hassan Basic, that's the officer, "we protect our own," or words to that effect, Goldenberg had communicated a specific message to all police officers: stay on our side, or there will be consequences. The judge stated, it is reasonable to infer that this has a real potential. Sorry, yeah, it was Marnie Goldenberg is the lawyer. I think I may have said Green. Green is the judge. It is reasonable to infer that this has a real potential of having a chilling effect on officers testifying contrary to the prosecution's theory. The only way to preserve the integrity of the justice system is for this court to distance itself from the conduct and enter a stay of proceedings. So a judicial stay of proceedings means that the case is over. It is dead. It throws the case out. So the accused in the case is, is innocent, because you're innocent until and unless proven guilty. And so if the case gets thrown out, you're not found guilty. So whether or not the person factually did it, they cannot be convicted unless there's an appeal that is successful. Now, I would say that if this, based on these findings of fact, based on these court findings, that would be a situation where where, quite frankly, I don't think that prosecutor can continue to be a prosecutor. And I'm not sure that that prosecutor should be able to continue to be a lawyer at all. So those are important, important considerations there. Somebody asked what kind of chilies. I don't know if you guys are familiar with these. These are Thai chilies. My fingernails are gross. Okay. So these are Thai chilies. also known as bird's eye chilies. They are very spicy. So yeah, they're not the spiciest chilies out there, but they are little tiny things that do not fuck around. Runkle, can you give us your thoughts on the rabbit skin case in Edmonton, where the cops threatened the officer that they would release info to the public? If you're thinking of the one I'm thinking about, where the cops threatened to basically threaten the court with, if we don't get what we want, we'll release info. The court had some very strong thoughts on that, and I also think that is a I also think that's a pretty serious allegation. And well, it's not so much an allegation. They did it publicly, but yeah, I mean, that I got to be careful about what I say on that one because it's my local neck of the woods. But it's a pretty serious allegation there. Quite frankly, that one, it's going to be a shit show. There's a couple of them here in Edmonton that are a bit of a shit show. There's that one. The other one is the De Ruyter case. The De Ruyter case is really... so De Ruyter was accused of being a cult leader, and as a cult leader, accused of essaying like several of his cult minions, I guess. And the case was eventually thrown out because the prosecutor apparently edited the expert reports. And that is shocking. The prosecutor who it's been claimed has done that, although the Crown has apparently stated in court record that this was a thing, was Damina Hussein. Previously on a previously on a thing, I had said so previously I had said that Aisling Ryan might be involved. Aisling Ryan is not involved. And the reason the new information I have is that Aisling Ryan was the secondary prosecutor on that. But apparently the information I've heard through the grapevine, which I can't confirm for certain, is that Aisling Ryan was not involved in the editing, but instead was the one who said, hey, this shit's been edited, and that's a big fucking problem, and this should be, somebody's got to know and called attention to it. So apparently Aisling Ryan is the sort of the good prosecutor in that and deserves to be commended rather than condemned. So, but yeah, I mean, if those allegations are made out, I just don't see how I don't see how they can pursue that. Like, that's just, messed up. So, all right, let's I see people saying that there was a super sticker and I do see a super chat or a Rumble rant or whatever they call them. Really, a Catman says confusion around the goal. Lol. So I guess we'll break one open here. I'm feeling a little apprehensive because I'm a bit out of spice practice, believe it or not. All right, let's find a decent one here. Which is gonna kill me least? You're like, that's not what we're paying for, Runkle. We want to see pain. All right. Is there one that isn't going to take too many bites? These are all kind of long. All right, here we go. We got a chili. Pick the red one. They're all red. They're all red. Somebody's snarky. Out of spice practice. I mean, a little bit. Little bit. So I had a thing where Whew. Whew, I'm feeling that. Whew. All right. And my computer. All right. I'm gonna regret this. I'm already feeling that. So when I order like, so I went to a pho place and I ordered spicy soup. And then I asked them to bring me chili oil, which is also spicy. And so they brought me the chili oil. And then I was like, can I also get a spicy pepper? And they're like, didn't you put chili oil in this? And I'm like, yes. And they're like, and this is our spicy soup. I'm like, yes. And they're like, and you want a chili pepper? I'm like, yes. And they're like, really? And I was like, come on. I have been known to order stuff. What is it? I ordered stuff on like online on Skip the Dishes, and I've been known to put in the like, you know, comments section, you know, make it hurt. I had a place that I ate repeatedly and the flavor was good, but they never gave me enough spice. And so eventually I was like, I want it spicy. And they're like, okay, spicy. I'm like, very spicy. They're like, very spicy. And I'd ordered very spicy before. And I was like, no, no, no. Look at me. Look at me. I want you to tell the chef that he is not badass enough, or that he is, you know, that he's not able to make a soup that is spicy enough for me. And the chef came out and was like, basically the equivalent, the Vietnamese equivalent of, are you fucking sure, white boy? And I was like, yes. And he's like, game on, motherfucker. And he brought me a soup that was so spicy that yeah, I had some regrets. Does your wife like spicy food? Not to the same extent I do. She does, but not as spicy. And then I can't handle some barbecue sauce. Let me tell you about Tait. Tait, I think, is okay with this. So, Tait and I went to a Mexican place. Tait was like, I like Mexican. So we went to a Mexican place. I've got a seed stuck in my teeth. Ooh. So, Tait orders the nachos because the Tait is a spice wuss. But you don't know how much a what is it? A spice wuss Tait is. I say this with all the appreciation, all the love, but Tait is an incredible spice wuss. So Tait goes and asks the what is it? And they bring out these nachos and they're dusted with like a tiny little bit of like chili powder. Just a little tiny bit. Tiniest little bit. And she had to send them back. She and I was like, really? Because I thought they were actually quite tasty. They were really, you know, it was just that little bit of flavor added to the. I was like, this is awesome. And she's like, no, these have to go back. Oh my God, I'm gonna die. And I was like, it was funny, and I teased Tait over it, but yeah, it was it was cute. So yeah, I don't think I've sent anything back for being too spicy in a long time. I have ordered things where they've made me pay in advance. And yeah. I had some hot wings at one point where they so the hot wing place that I was at, well, I did a hot wing challenge at one point. I used to have a card in my wallet that was entitled me for free wings for a year. And the way I got that is that they had a hot wings challenge where they had like really, really hot wings. And so to get the card, you had to finish like 10 hot wings in like a minute or 2 minutes or something like that. And they were really spicy hot wings. And I was pounding those down. And they're doing this as like a big event, right? So they've got like cameras on you, they've got a microphone, and I'm just pounding these things down. And Buddy with the microphone sticks the microphone in my face. And he goes, "How are they? I bet they're really spicy." And I went, they're okay. And he went, that's all you have to say? I'm like, they're okay. And then he moved on to the next person. So the thing is that's actually kind of sad is that those wings fucked me up. And you might be saying, "Oh, well, the spice got to you in the end, didn't it?" You know how it got to me? It wasn't the spice that got me. It's that because they were doing this as an event, what they ended up doing was they ended up like they're doing this as a big, big sort of demo thing. And so they were pulling out like batches of chicken. They were cooking batches of chicken. You sent 4. I don't see 4. I only see 2. But they were pulling out batches of chicken basically as fast as they could. And so they were not cooked properly. And I had a moment as I was eating them. You can see my nose is running a bit. I had a moment as I was eating them where I looked down at the wing. And I've already like eaten most of the wing, right? So I looked down at it and I'm just like, it is like raw chicken inside, right? It is just raw fucking chicken. And I'm like, oh God, no. So anyway, I went and what is it? I finished the wings, but later on I was throwing up. Like, I spent the rest of the night throwing up. And I gotta say, of all the aftermaths, throwing up spicy actually really sucks. So yeah, and this is about how it went. Well, I already ate a bunch of it. May as well win the damn challenge about it. Yes. So we won the challenge, and then they give you the card. And the card says, "Good for free wings. Any Tuesday with the purchase of a drink." Which is like, you fuckers. You said free wings for a year, and now you're adding on a bunch of wrinkles that you didn't actually, like, you didn't put in the initial thing. So, here's the further problem. We went every Tuesday for about 4 months. And then the bar rebranded. And when they rebranded, even though it was the same fucking owners, when they rebranded, they were like, oh, card's no good no more. I'm like, you bastards. Yeah, I was not I was not happy about that. I very annoyed by that particular aspect. And they rebranded the what is it? They rebranded to get out of the honoring the year of free wings. You're not wrong. I got the feeling. I mean, they rebranded to a different kind of genre of bars, but I was still, yeah. I would sue not because I'd care enough to win, but just because I'm petty enough to waste my time and theirs over it. You kept going back every week to the place that served you raw or undercooked chicken? Yes. They served, the chicken was fine when they weren't pounding out batches of chicken as fast as they could. The chicken was fine. Right? So, yeah. One was at the start of the stream and was long about Randazza, clearly not being a Marvel fan. I did not get that one. Then there was the magicians or bards who don't get laid. Can't recall the other two. Oh, well, not worried. I'm sorry, random unbreaded. What is it? Yeah, chicken freaks me out. Chewy and dry in order to not die. I mean, you can make good chicken that's cooked all the way through. All right, I got to finish this. I am down to almost... I'm not eating this piece. Oh. Oh, yeah. Seeds everywhere. You can actually make a decent chicken tartare so long as you sous vide it. It's not worth the pain in the ass, but you can do it. Get some milk after the stream. I need to rinse this. Ooh, there's a seed in there somewhere. Whew. Where's that seed? There's a seed still in my mouth. Ah. Whew. Huh. I'm only mildly dying. Oh. All right. Let's cover super chats and then let's wrap up. Michigan Farm Boy, we don't like it is in good faith in my court. I suspect they're going to win on that argument, but I hate it. Shady people in power being shady. Lovely. Yep. East Coast, Revenge of the Fifth. Not quite there yet. Fifth is also a fun day for me. So, Kimchi, the forensic homeopath. What kind of chili pepper, though? What are the little metal coin or metal looking things on the shelf behind you? Those are challenge coins. I will go through the challenge coins on another stream. I'm going to wrap up here, but yeah. Pretty fly for a Wi-Fi super sticker. Thank you so much. My eyes are watering now. I have a seed stuck somewhere in my mouth. And so it's still spicying me. It's not stopping. Oh, that is hurting a little bit. I got to go deal with that in a bit. Michigan Farm Boy says extorting / blackmailing the court seems like a bad idea. You're not wrong. They're all kind of long. That's what she said. I'm not going to play up on that one. I sent at least 4 Rumble Rats. Think you got 2. I think we saw that one. Go ahead. Rub your eyes. They'll feel better. No, I am going to wash my hands very carefully. Do not, important chili safety tip. After cutting or handling hot chilies, do not rub your eyes or your genitals. Instead, you need to wash your hands very, very, very carefully. And if you need to test whether or not you've washed your hands sufficiently, there's a simple test. And the simple test is handle somebody else's eyes or genitals and see their reaction. And if their reaction is misery, then you know that you should not, that you need to wash more. Yeah. Don't test it on your dog. No, that would be weird. All right. Thank you all. And what is it? I will see you guys later. Good night, all.